Yes.
For hearing item 15 as a first item.
May I please? Lordship, here the petitioner's predecessors are the pattadars of 8 bighas, 2 kathas and 15 lechas of land in Barpeta town, Your Lordship. Thereafter, in the year 1962, the same was acquired by the respondent authorities for construction of the NH-31 highway, Your Lordship. Then the compensation for the said land was not given to the petitioners. Thereafter, in the year 2009, the petition number 1 had preferred a representation before the respondent authorities, that is the Deputy Commissioner, Mother. Thereafter, on the additional Deputy Commissioner cum Competent Authority NHAI had made an inquiry, and the inquiry report is enclosed as Annexure A, Your Lordship. Starts at page 14. Relevant portion at page 15, Your Lordship. Second para. Your Lordship got it? May I read, ma'am? Again, schedule of land acquired from patta holder, late Sukhada Bala Dasya. It should have been Das, Your Lordship. Wife of late Sita Mohan and Sri Dinabandhu Talukdar, the petitioner number 1 herein, who is the deceased Lord. For construction of 31 National Highway during 1962, which has been corrected in the name of 31 National Highway by converting the periodic patta into government sarkari why the then Deputy Commissioner Kamrup's order memo number so and so. It is pertinent to mention herein that the aggrieved patta holder as acquired and shown above stated that they have not received the compensation for the land for the National Highway Authority or any other source. Copy of the land records and report of circle officer along with LM concerned are enclosed. It is revealed from the records that necessary correspondence have been made to Chief Engineer for taking necessary steps on non-payment of compensation to the patta holders of the land as stated above, which has been acquired for construction of 31 National Highway. By this office letter bearing number so and so, and in response to the said letter, the Chief Engineer has made a clarification that there is no records traced out on their hands for payment of compensation to the pattadars against the land acquired in 1962.
How
Now-
do they have records? This happened in 1962. You have come in the year 2009.
No, Your Lordship.
No. This is not a case by
Lordship.
which anything can be
Lordship,
reopened.
9.
You had slept over.
Lordship may see my affidavit in reply, Your Lordship.
My affidavit in reply has
Page 26, Your Lordship. Letter from the subdivisional officer to the petitioner's mother, Your Lordship. Lordship got it? Page number 26. With reference to your petition dated 24/9/1970, it may be stated that the LA case is pending with government of PWD for sanction of funds. Further action to
Why, if it was acquired in the year 1962,
Lordship.
and you have not got somebody writing a letter to you, does not give you anything, why didn't you take any action in 1976?
Lordship, we were approaching the
There is section 18
Lordship.
of the Land Acquisition Act 1894 didn't say that when a land is being acquired, you have to file, there is an award being passed. What steps did you take?
My lord, in
When
this,
was the award passed?
my lord, there is no record to that effect, but
No, nobody will have a record when you approach this sport after such a long time. You approached this sport in the year 2014.
after the inquiry was done by the
No inquiry.
Lordship in this regard, one Supreme Apex Court judgment, Your Lordship.
Yes. What is the name?
Lordship. Vijay Latka and another versus State of Haryana. Paragraph number 6, Your Lordship. Next page, Lordship. Paragraph number 6. May I read, Lord? Paragraph number 6.
Yes.
The contention of the Learned Council appearing for respondents is that whoever approached the Haryana Urban Development Authority or the Company Authority has been paid compensation, and since the appellants failed to approach the
No, here it does not show when the acquisition has happened.
Lordship, but the Honorable
It is
Apex Court has
stated
held
that
that,
award was made on 31/10/2005.
my lord, but
And
the
the petition has approached out there in, the writ petition approached this notification in 2002. Writ petition was filed by the appellant challenging the notification issued under section 4 and the declaration and award dated so and so. The writ the dismissal on the ground, sole ground that it has been passed and the writ petition is not maintainable. This is on the basis of which it was filed.
Lordship, but the Apex
That-
Court has held that when a land is compulsorily acquired, it is for the requisitioning authority to make the payment and does not require the landowner to come and receive the payment, Lordship. Paragraph number 6, your Lordship.
No, no, no.
Lordship, there is another judgment in respect of the delay, Lord.
That case, this.
Paragraph 13 to 20 and 23 to 25, Lordship. May I read in respect of delay, Lordship, paragraph number 24.
No, 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 this is not the case. You see, here the facts were what? The land was being occupied by somebody
Lordship,
and they did not acquire.
Lord.
And therefore, he approached in the year 2011, although it was taken on 1972, but there is a continuing cause of action taking into account that land was in possession of somebody because you don't lose your right.
Lordship.
But here is a case where you have lost your right.
Lordship, there are representation which has
No,
not been.
representation is nothing. This is not a case. You have to understand there is a fundamental difference. When the award is not there, what happens when an award is there and a possession is taken under section 16? The moment the possession is being taken, the land vests upon the state, upon an award being passed. Now, in the instant case, the land have been acquired
Lordship.
as far back as in 1962. You lost your right. Whereas in the case of this as well as in Vidya Devi, the land was not acquired. What was done is they have taken over the land and therefore you continue to remain as the owner. And therefore there is a continuing cause of action. Because an owner does not lose the right over the land till the right stands extinguished by operation of law.
Lordship.
So therefore, this in Vidya Devi's case is in respect to that. And therefore, what this person concerned filed in the year 2011 that kindly acquire my land and pay me the compensation.
Lordship.
How do you have the same principles applied here? Here is a case in 1962, the land has been acquired
Fine.
and you approach this court in the year 2014. You won't have any records to the effect and it is the most difficult
My Lord, may
thing.
allow me to file
Then-
an additional
If
affidavit.
I allow your petition, then I will be circumventing or I will be going contrary to section 18. You say that you did not get the compensation. Do you have the Land Acquisition Act with you, 1894?
No, no.
My goodness, you are arguing without the Land Acquisition Act context. Good. Yes. Which one? New or old?
Old.
Old. See section 18. What does it say?
Any
Read what?
person interested who has not accepted the award may by written application to the collector require the matter to be referred by the collector for determination of the court whether his objection to the measurement of land, the amount
So
of
the
compensation.
first is the measurement of the land. Second,
Compensation.
no, read. Without reading
Measurement of the land, the amount of compensation.
amount. The third,
The persons to whom it is payable,
so it is payable to you. The third. And fourth,
or the apportionment of the compensation
so
among
it is amongst, if there are more, it will be the apportionment. So these are the 4 parameters you have to do. And you have to file this application within what time? See, 18.2.
The application shall state on the grounds on which the objection of the award is taken, provided such application shall be made if a person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of collector.
Obviously, you were not present, so 6 weeks won't. Then
In other case, when 6 weeks of the receipt of the notice from the collector under section 12 subsection 2 or within 6 months from the date of collector's award,
so
whichever.
from within 6 months. Now, the land has been acquired. You know it. Your forefathers knew it. You did not take any action. Now, if I direct now to take the compensation, means I am touching on 18, one of the 18.1, one of the 4. Wouldn't I be going against
Again.
18.2? Whereas if the land was not acquired and your land was being taken over, then the question would have been different.
Good.
That is the case. Anything you want to say? Yes, submit. Otherwise, I will just say that Mr. S. Dutta noted his head.
Lordship,
Then,
here, annex one document, Lordship, page
Hmm.
14. Page 14, some Patadars also, their name of the Patadars there. We have approached this honorable court. This honorable court has dismissed the petition, their petition, and against that order, appeal was filed, appeal was dismissed. Filed.
Case number two. Case number two.
Petition and appeal.
and these were the persons
Lordship, page
Who?
14, Lordship.
who approached this court.
Hemanto Mandal, Lordship, this was. Patadar,
Pattada approached.
Lordship.
And they are,
Their name also there, Lordship, in that report, Lordship.
their name,
Page 14, Lordship.
In the second schedule, Lordship.
huh?
Page number 14. Page number 14, Lordship.
40
14, 1-4.
of,
Lord-
Writ petition.
Of the writ petition. Lordship, I am not aware about the writ petition being filed, Lordship.
you are connected with any of these people? These Mondal people?
No, Lordship.
Page 15, Lordship.
Huh?
Page 15. Her name is there, Lordship.
Wait,
15, 1-5. Second para. Again, schedule and then it were from Patta holder, late Sukabala Das, wife of Sita Mohan Das. This is it.
no, whether these, the year of
If I,
Kukla Bala Dasha, whether these people are, their successors have filed this petition? No.
No.
But you are saying that in respect to the same order,
Lordship.
in same order which is there at page 14,
Lordship.
these are the persons who have already
Approached.
approached and this court dismissed the
Dismissed.
petition. And the matter went to the division bench family.
Dismiss that. The division also dismissed. Appeal.
So,
Okay,
so
order
the
is there.
appeal was, judgment of the single judge was affirmed.
Affirmed.
That is what you are saying.
Lordship.
So you say that same principles will follow here.
Delay and lesser lordship. However, it was taken, that was taken by the earlier judgment.
So you make another submission which I have said. That if I pass an order,
But that,
it will be in contrary to the mandate of section 18. Make the submission. It will look better. Hello, let us dismiss. Heard Mr. M. Sahiwala, the learned counsel appearing on behalf of the petitioner. Petitioners and
My
Mr.
lord, when you also dismiss, my lord, my name may be shown, my lord,
Yeah.
that will be better, my lord.
Do you want to say anything more?
No, I have not really seen now. Actually,
Heard
it is the
Mr.
duty of the,
James-
my lord, the state, my lord, to pay the compensation. That is,
Huh?
it is a duty of the state to pay the compensation.
You should also approach the court, approach them early. Heard Mr. G. N. Sahiwala, the learned senior counsel, assisted by Mr. M. Sahiwala, counsels appearing on behalf of the petitioners. Mr. S. Doctor, the learned counsel who appears on behalf of the Revenue and Disaster Management Department. Ms. Lee Das, who the learned additional senior government advocate who appears on behalf of the district administration. The petitioners herein have approached this form in the year 2014, alleging that in the year 1962, for the purpose of construction of the National Highway 1931 under the Borpeta Road Town in the district of Borpeta, Assam, land of the petitioners were acquired, but no compensations have been paid.
Yeah, that's the thing.
It is seen from the materials on record that there is no denial of the fact that the land of the petitioners were acquired in the year 1962, isn't it? There is no denial of the fact that you acquired
lordship.
of the petition of the land belonging to the petitioners were acquired in the year 1962, which were covered by DAG number 159/1847/1850 of KP Patta number 789 of village Borpeta under Moza Gobardhana in the district of Borpeta, Assam. The record further revealed that the petitioner thereupon did not take any further steps and kept quiet. And the record further reveals that the petitioner did not take any steps in terms with section 18 of the Land Acquisition Act 1894. It is being submitted that there were certain representations submitted. It is being contended that the certain representations were submitted on 37/2009, which is after a period of 47 years
7.
claiming compensation. It is, record further reveals that there was an inquiry report being made. And it is the grievance of the petitioner that even after acknowledging that the petitioner's land were acquired, no payment was made. And as such, the present petition. This court have also perused the affidavit in opposition which have been filed by the respondent, number one. Wherein it was mentioned that the claim of the petitioner is not tenable. Inasmuch as after making necessary acquisition, after carrying out the acquisition, the petitioner never approached the authorities. Even the land records were, the name in the land records were changed in the year 1969. It was further stated that the claim of the petitioner was also rejected by the additional chief secretary, Revenue and Disaster Management Department. This court have also perused the affidavit in replies for submitted, wherein the respondents, the petitioners enclosed a communication dated 30/10/1976. Issued by the subdivisional officer, the Borpeta. In the backdrop of the above, this court have also heard the learned counsels appearing on behalf of the parties. Mr. G.N. Sayola, the learned senior counsel, placed before this court the judgment of the Supreme Court in the case of Sukdat Ratra and another versus State of Himachal Pradesh and others reported in 2022 7 SCC 508. And submitted that as the rights of the petitioner have been violated under Article 300A of the Constitution, the petitioners were entitled to the compensation. This court had duly perused the said judgment rendered by the Supreme Court in the case of Sukdat Ratra, Supra. And in the opinion of this court, the principles laid down therein would not apply, taking into account that in that case, the respondent, the authorities concerned had possessed the land of the petitioner therein without acquiring the land. And it is under such circumstances a writ petition was filed seeking appropriate directions for acquisition and thereupon making payment. It is the opinion of this court. However, in the instant case, admittedly, the lands were acquired in the year 1962. And by operation of law, that is Section 16 of the Land Acquisition Act 1894, the land stood vested upon the state. The petitioners thereupon did not take any steps as is required under the Land Acquisition Act 1894 by filing an application under section 18. And it was only in the year 2009 that a representation was submitted. In the opinion of this court, the instant writ petition therefore suffers. The act on the part of the respondents, act on the part of the petitioners amounts to sleeping over the rights It is a settled principle of law that a court is not expected to give indulgence to such indolent persons who compete with Kumbhakarna, or for that matter, Rip Van Winkle, as in the instant case. Considering the above, the instant writ petition stands dismissed. However, in the facts of the case, this court is not inclined to impose costs.
Item 16 fixed as second item.
Yes.
Yes, madam. The
Yes,
matter relates
So
to,
argue.
yes, madam. The matter relates to, my lord, a shifting of the IFL off of my lord.
When are you shifting?
My lord, as per the requirement, my lord, page 27 is the impugn letter, my lord.
When are you shifting?
My lord will,
How are you running today, Mr. Ghosh? How are you running? Last time I asked you a question. How are you running? Have you been extended? Initially, 3 years were given. Then what has happened?
I know we have made an application in 2019 also for recognition.
Are you being permitted to run?
Yes.
Where is that?
2019, my lord. You have given.
Where is the document?
Also, my lord, just. We've applied for, my lord, both the Ahungav and the R.D. Borua Road, that city center.
How are you running your college from there?
So, my lord.
You were initially given for 3 years. Then what happened?
2019,
What has happened?
Then my lord, it has been extended to 2000. Just a copy.
Absolutely, the next one.
Item number 2. my lord. Just a hazard.
This is at Ahumgaon.
I applied for that too, my lord, but it is a city center, my lord, we say. There, my lord, permission they get of that house ground. So that is
No,
correct.
you were asked, given this permission for 2 years, 3 years.
Yes.
How are you operating thereafter?
Pardon, we have been allowed, my lord, because
How?
I obtained
How?
2019 only.
How?
They have to obtain instruction on that matter.
That is what I asked you on the last occasion.
So the,
We asked you,
yes,
first of all, you cannot have a college without permission.
yes, my.
How are you having it? We
Pardon,
should ask you to close down. You'll ask your college to be closed down. This cannot happen without a permission. This, it will come under the higher education or secondary education.
Secondary, madam.
secondary.
Secondary education. Get hold of a council from the secondary education. We close it. Anybody from the secondary education?
My lord may take our name.
No. We close down your. We close down, then his shop is there. No problem. People get revenue. This is not the manner in which you have to approach the store. You were initially permitted only for 3 years.
No,
The report shows that you are still running.
yes.
That is what is being shown. But are you running with a permission?
My lord, that I have to obtain, this issue did not pop on the, only last time my lord had asked me, my.
Mr. Gogoi, you were there. Should I again rewind that hearing which will happen on that date? Didn't I ask you on that date?
My lord,
I asked you on that date.
yes, my.
That,
My lord, I tried to contact my lord, the person out of station, my. That is why I could not get in touch with the,
oh, has he gone to the moon?
no, my lord.
Because everywhere otherwise the mobile network goes.
My lord, I have to obtain the instruction.
Get the instruction in 10 minutes. Do you have the permission or not? And if he has the permission, to provide the WhatsApp copy. 10 minutes.
Two, my lord.
10 minutes. Otherwise, we ask you to stop. Don't run from there. Without a permission, how are you running a college out there? Otherwise, it will come within the ambit of a tutorial. We'll go as per that it is a tutorial. I don't know. If they are doing it, because let us see that Assamia secondary education rules, that without the permission you cannot run. And these are non-government, na?
Non-government, madam.
Non-government, there is a rule made under the non-government.
Yes,
rules. So there, if you want
The
to
act
run,
and
you
rules,
need a
right.
permission.
Yes.
And if that permission is not given, then if they are running it, it should be closed or it should be treated as a tutorial,
It should be treated as private coaching or tutorial.
private coaching. So they can very well go ahead and you should close down. How can a private coaching also? Have you taken a trade license and all these things?
Yes,
Then it is a business. It should be closed immediately. Running a tutorial with a wine shop, does it look nice? Where is the provision? We close down this type of things. Ah, yes. Tell me. Can madam, tell me. A college or a school, a higher secondary school can run on the basis of a permission? If it's a non-governmental, then also a permission is required. You have to give a permission, non-governmental. Now, can they have a branch anywhere without a permission? So we close down this. Non-governmental educational regulation of fees here. Yes, sorry.
573 of this edition, madam.
We close down this type of. Mr. Ghosh has taken this vote very lightly.
573 Lordship will
I
find
asked
the act
you on that day and you have taken. this
and
vote
my
for,
lord,
right? Non-governmental education. I think. Assam, Bigha.
under section
powers of the
6,
State to regulate. The state
Section
government may
6.
regulate all non-governmental institutions in the state in accordance with. By permission by ability. Any individual association and man intending to establish and run a non-governmental non-given years when so may submit an application before the director in such form containing so and so. Provided that the director may refuse to grant permission if he is the opinion that the particular than information furnished in him. The refusal to grant permission under the director shall indicate the reason. In the event of it, the permission granted under the act shall remain valid for a period of year within which administrative recognition after the establishment and registration of non-government under the paying so authority shall make an application for on payment of such fee and inform of Education and recognition.
proviso to section 6.1, I think will apply. my lord.
6.1.
Section
close
6.1,
down.
proviso 579. page.
Provided in the failure of any institute to register the
Within an
institution
existing
under
non-government.
one within the stipulated, the institution shall be allowed registration on payment of fees 50% increase of the year. This is different. But the fact that they don't have,
Yes, my lord.
so it has rendered itself into a status of a tutorial or private institute or a private coaching class. And once I say it to be a private coaching class, it loses its identity. And you paste it out there in every newspaper also that it is a private institution, private coaching class.
Coaching.
Nobody will join his school also. Put that in the. Every non-governmental LOS shall maintain a list of properties, both movable and immovable, also and so. Withdrawal of recognition quota for where any government so and so fails to fulfill or comply with the provisions of the or violates any of the provisions of the act or so and function in a without being registered under is liable to be closed down and in the event of closure the individual association. So and so. Not done. And there is also a form. Form has also to mention the area. Where is it? Where is the form? Yes, yes. Application for prior permission. You see.
Yes, my lord.
Name
Is
of the
651.
members, whether registered proposed name of the interest, stage of so and so, location of the proposed so and so, name of the category of institution, radius of so and so, status in case of a leaseholder so and so, whether so and so. Then they have not shown us undertaking. And you open a year. And who's building it? Who's building?
As per my instruction, one Tilak Sharma is the owner of the building.
Then we close down this institution. If we close down your wine shop, you mean?
Yes, my lord.
Take the inspection report, there's a form. Building, see? Page 631. Type of building with
Yes.
built, whether single story, whether so and so, whether institution, whether there's a thoroughfare as so and so. So without a recognition in respect to that particular branch, it has rendered itself to the status of a private.
Coaching institute.
So nobody should go and study there. Hello, let's pass that order. 10 minutes, you get time.
Malo may take up two, my lord. I tried to contact Malo. He's out of station because.
That is why I'm saying, if a
Yes.
person is out of station,
No, I-
does it mean that
Because
he is in the
person,
moon?
lordship, let me submit the person who is looking after his son, my lord, he recently got married. So he's out of, that is why my lord, I tried to contact, he's out of station. There's the impediment, I will, lordship may note it and can pass it. But I was asking because my lord, He is out of station.
No,
I-
you should have got that
Also, I tried to
information.
Contact him, my.
No, whoever it is,
Right.
okay, get it by 2. We passed it on.
Let him apply to your place.
2,
We have study of study.
2 o'clock. Get your information by 2 o'clock, whether you have got any further here. And madam, why are you allowing him to run this? Because last time there was a direction for inspection report. If he doesn't have the permission, why are you allowing him to run? You can't allow a school to run from any place. A non-governmental organization cannot run wherever they feel like. Because what they are trying to show, that we are a college. We have got the recognition. But their recognition is in Ahunga. But they are having the tuition out there. And it has been rendered to you as just a private tutorial. You have to close down or say that you don't have, this is the reader. Because otherwise the students are being duped. We are concerned about them. These people, they are thinking that they are studying in a college. What they are doing is actually studying in a hybrid mode. Isn't it? 2 o'clock.
For motion item 1.
What is this? E-voter. How many times? First time.
1987 he has been marked as D.
Huh?
In 1987 he has been marked as D.
19?
97.
And what are you doing?
My
From
lord,
97 onwards. You must have been already declared.
my
Are you
lord,
still here in India? Or
yes,
pushed
my,
back?
yes, my lord, but
What is your
I
instruction?
am not aware of that, my
No,
lord.
no, he has already.
Whether-
Is there a person who has signed this? Your name is there in
My-
the NRC.
I am sorry to mention before your lordship, actually this matter is not pertaining to me. One, Ziaul Hussain ISRO report is not in my hand, but instruction was there. T was made in connection with my,
See why I'm saying it. The petitioner's name has been shown as SOSADURA. Sabura. But her affidavit is SOBURA. Why? Why?
my lord, that is to be my lord. Corrected from getting information, my lord. Actually, report is not my hand, my lord. That is why, my lord, I could not submit it. My name is there. The matter relating to Mr. Z.H. Ahmed, he is suffering ailments. And
Where was your name earlier?
Electoral roll of fellowship.
Show me in the
But
voters list. Your name is there.
Page number 22 also. Voter list of 1997. Serial number 1125.
Page?
Page 22 also.
Where?
Down in the left hand side also. Serial number 1125.
1125. Tupura Khatun.
Sabura Khatun Motleb Ali.
What is it? Motelab.
Motleb Ali.
Motelab Ali.
You-
Motelab Ali is what?
Husband. As part of affidavit, he is done.
He got married in the year 1997. And prior to that, you were devoter or not? Where was your name prior to that?
my lord, I pray your lordship, my lord. The record is not my hand. The record is in the hand of my lord, Mr. Z.H. Ahmed. The case is relating to Mr. Z.H. Ahmed. He is not before this court, my lord, because he is suffering some ailments. And that is why I have
Oh,
some
you
problem.
stated none appears for the petitioner.
No, my lord, my name is here, but the case is relating to my lord that
Your
Mr.
name is what?
M. Hussain, my lord.
Huh?
M. Hussain. So I pray,
So you don't know head or tail about the matter?
my lord.
Okay, Mr. M. Hussain submits that he is not
Aware of-
aware of the facts of the case,
My lord.
who's taking into account the above matter be listed after 4 weeks.
Obliged.
Item 17 for admission, part heard.
Oh, yeah. Yes, Nandi. Why did I fix it? S. Nandi appeared. What is this case?
This is the case whereby the petitioner was asked to shift his license, IMFL off license.
Oh, that matter.
Yes, yes. The objections is 24 people are there, 18 people said no, gave NOC, 6 people said we have objections. And
Then also there are 6 people.
yes, and he even in his reply, he admitted that there are 6 objections are there.
Huh?
In the show cause notice, which we have issued, in his reply, the petitioner admitted there are 6 people who have objections regarding setting up this shop.
Yeah.
That's the issue.
So you have asked him to shift.
We have asked him to shift, he's challenging that order.
Okay. Okay, none has appeared on behalf of the petitioner on call. On the other hand, Mr. R.R. Gogoi appears on behalf of the Excise Department. The petitioner herein have assailed the order dated 23/2/2023, whereby the petitioner has been directed by the Deputy Commissioner, Kamrup Metro, to shift to any other location that conforms to all the norms regarding location of a liquor shop, or else appropriate steps will be taken for closure of the shop in terms with the Assam Excise Act 2000 and the Assam Excise Rules 2016. This court finds it pertinent to take note of Rule 289, na? Assam Excise. 289. 289 was it?
295 will of.
295.
Local
Finds
bodies.
it pertinent to take note of Rule 295. Of the Assam Excise Rules 2016. Which amongst others stipulates that objection from persons, objections from owners or occupiers and residents of the neighborhood located within a radius of 75 meters of the premises involved shall be considered. The materials on record further show that an inquiry was conducted pursuant to certain complaints being filed. And it was found that within 75 meters of the petitioner's shop, there were 24 persons, occupiers, residing. And out of that, 6 occupiers had objected. This aspect is also acknowledged by the petitioner in the reply to the show cause dated 13/12/2023. which reads as under page 66 what? I say number 1. Next. It is pertinent to observe that no person have a right to carry on the business of liquor. It is merely a privilege. For the purpose of exercising the privilege, the person concerned has to follow the mandate of the Assam of the law. That is the Assam Excise Act and the rules framed therein under. In the instant case, as there is an objection raised admittedly by 6 of the occupiers coming within the ambit of 75 meters from the shop of the petitioner, this court does not find any good ground to entertain in respect to the challenge stated 23/2/2023. Challenge to the order dated. Accordingly, this court therefore dismisses the writ petition. Interim orders passed earlier stands vacated. You are appearing? Okay, and I'm to the review.
Admission item 2, Delhi. Lake.
Oh, Sankotra Netralo and none appears for the petitioner. Who is there? Yes, what is this? What are you challenging?
So we have challenged an order dated passed by the Labour Court in reference case number 8 of 2008, Lordship.
Okay, what is that?
Lordship, here the issue is that the respondent number 2 was appointed as a nurse in the petitioner's hospital. Thereafter, she went on leave. Thereafter, a show cause notice was issued to her. Then she replied. Then a charge sheet was laid down, and out of that, 10 charges were there, Lordship. Thereafter, she was intimated by letter to reply to the charge sheet. Then she intimated that the same reply has to be considered, which she filed for the show cause notice here. Lordship, then the domestic inquiry commenced, and the inquiry officer has submitted his report. Then thereafter, a second show cause notice was issued to the respondent. Thereafter, she was removed from the service. Then she approached the labor inspector, Lordship. Then the government has
Mr. Das, you are getting the last drawn wages? Are you getting the last drawn wages?
Yes. No,
Why? You have not filed that application.
we not allowed.
Why? Or you are engaged in some other business?
Yes,
So you don't want reinstatement now, you want only that amount.
yes. At this moment, I don't want reinstatement below.
So only thing is, what you want is a reinstatement in the service in the same cadre which was holding before her remand, along with 60% except the period of her absence, is also entitled to litigation costs. So your limit, the prayer limit is only to 60% of the back wages.
Yes,
Or do you want to come back?
no, I'll not comment.
So you don't want to come back. So you, your limited prayer is as to whether 60% of the back wages you should get or not, along with the litigation expenses. Okay. Sure. Records are here. We'll have it on some other day when the matter can be taken up
Lordship,
for hearing.
Lordship,
Only that aspect.
Lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. S.C. Das, who appears on behalf of the respondent.
No,
Number?
number two.
Number?
Number 2.
Yes.
Number 2. The the instant petition has been filed assailing the order award dated 13/9/2022, passed by the Learned Labour Court, Guwahati, in reference case number 8/2008, whereby there was a direction for reinstatement of the respondent number 2,
Yeah.
along with back wages at the rate of 60%, except the period of her absence. It was also directed that the respondent number 2 would be entitled to litigation costs to the extent of rupees 20,000. Mr. Asidas, the Learned Counsel, appearing on behalf of the respondent number 2, submitted that in the meantime the petitioner is already, and the respondent number 2 is already working in some other establishment and does not intend to rejoin the petitioner hospital. So the only issue therefore remains is as to whether the petitioner herein, the respondent number 2 herein, would be entitled to 60% back wages, except for the period from the date of removal of her till the date of the award, except the period of her absence, and further to the litigation cost. It is also seen that the records are available. Considering the above, list this matter on 25th of November 2025, on which date an attempt shall be made to dispose of the writ petition.
Item 3.
Much obliged.
What is this?
What is a non-payment of dues to the petitioner for architectural consultancy services, my lord? On last occasion, my lordship was directed to produce the records, my lord.
Lordship,
None.
for the records, because at para 7, opposition.
What is this non-payment
Yes, my lord.
of?
Architectural consultancy services, my lord. Architectural consultancy services, my lord.
And why you are not paying?
Lordship, at our affidavit in opposition, para 7, we are disputing the claim of the petitioner stating that no record has been found at the office director and that any drawing, this is 3 and 4, have been received from the petitioner, Lordship. Now they are saying they have submitted, we are saying no, they have not submitted.
Thereafter, they have stated that in the same paragraph, my lord, it is pertinent to mention that no such works were executed for wing 3 and 4 of the hostel block of the college at Fisheries at Roha, my lord. Lordship may come to my reply, my lord, that we have filed. That we have annexed, my lord, the entire drawings, the construction that has done, my lord. Now they are saying that there is no construction, no works has been done, my lord. This is there, my lord, the wing 3, wing 4 hostels. Because of which, my lord, on last occasion, my lord, the Honorable Court has directed to produce the records, my lord.
Records.
Records, I have a week time, Your Lordship, we already got the records. Let it be taken up next week, Your Lord. I'll produce the records, Your Lord.
Okay, 10,000 cost. Today the matter was fixed. Will it fix? No. Okay, no cost. Next week?
Next week, Your Lordship.
No, next. Next week there are a lot of matters. Okay, one day I am not there, on 14th. Let the burden fall on some other judge. To stop. It is seen that so there was a direction passed by the court for production of the records by the Assam Agricultural University. Mr. R.R. Gogoi, appearing on behalf of the university, submits that he is yet to obtain the records. Considering the above, list this matter on 14th of November 2025, on which date the records pertaining to the construction work and architectural,
Yes, my lord. Architectural consultancy services, my lord. The drawings, my lord, along entire record, my lord.
the records pertaining to the contract between the petitioner as well as the university be produced before the school.
Obliged, my lord.
Item 4.
Yes.
But you have received the affidavit today. 2 weeks time may be granted for filing the reply.
For us, number 6, we are filing.
You file affidavit.
Yes,
What is that?
for the, in fact,
What are you asking, madam? What is your prayer?
So, respondent has filed the affidavit and we have received today.
Oh,
So
is
2
it?
weeks, yes, 2 weeks time.
Oh, it
may
has
be
been
granted.
submitted by, the affidavit has been filed by the respondent today.
6,
And the petitioner would like to go through the same and if necessary, file a reply. List this matter upon filing of such affidavit by the petitioner. Upon filing of the affidavit and reply by the petitioner. You file, then the matter will be listed.
after,
I,
after, lot may indicate sometime after 2 weeks or 3.
Why?
The,
There's a stay?
no, there is no stay, but the petitioners are occupying the approach road.
Oh, is it?
They are occupying
Chalo.
the corridor of the
Okay, okay.
marketplace.
Would like to file a reply. Mr. D. Nath, the learned counsel submitted, appearing on behalf of the respondent, submitted that on account of the present litigation, the petitioner is occupying a
Corridor of the marketplace.
corridor of the marketplace, which is creating a lot of inconvenience. Taking into account the above 7 days' time is granted for filing the reply. List the matter again on 12th of November. Reply by be filed on or before 10th of November.
I,
Yes, what
My
is
lord, this
this?
regarding, my lord, the issuance of IFN license. So I was the
What
L1.
are you doing, Mr. Mohanto, doing matters of IMFL license?
No, my lord, now,
This doesn't suit you.
no, my lord, they are on compelling situation, my lord.
Being a senior advocate, you can't pick up matter like this.
While I lived, my lord.
Yeah, the
Right.
senior advocate, you can't take up matters when it goes against your very idea about IFL license.
Now here, my lord, actually, I forget it now. My lord, I want to withdraw my money. Because of their, my lord, indifferent behavior, I have deposited the amount long back in 2024, my lord, January. Till today, my lord, because of the no objection from the municipal board, my lord, they have done nothing. Now passes speaking order, stating that now they pass a speaking order. So here means Palasbari municipality board has not given any permission. So that's why you agitate the matter before the government to shifting to give a license in a different place. But my lord, my condition is now, my lord, health condition is not good, my lord. So now I want back my money. That there is third pair I am sticking, my lord. $295.
Would it, they have issued the license.
No, not yet. No license not issued, my lord. I was L1. I was asked to deposit the money. 72 near about 75 lakh I have deposited, my lord. I have 73 lakhs deposited. I have, my lord, some.
So they are going to give it with interest.
My lord, that's why, my lord.
You want interest?
That is my third pair. Now, my lord, I am.
You want interest?
My lord, I am on interest.
You are an MSc,
My lord.
MSME?
No, that is no. It is personal. No? Personal.
You are MSME?
No, personal.
You pay return with interest?
Lordship, the NOC has not been given by the municipal board, your lordship.
Then why you are holding? He doesn't want the money. You go ahead, do any business with the excise. He wants the money back.
Deposited in, my lord.
Because
That is
immediate speaking order has been passed, your lordship.
yes.
Good. You have not cancelled his license.
We have not cancelled because he's a H1 bidder.
You have not issued the
We
license.
have not issued the license.
So then,
If he wants EMD back, this initial deposit which is
now
submitted,
if there is an objection being given by the municipal, wouldn't it come within the ambit of 295?
295,
So if it comes under 295, you cannot give him.
we cannot give.
Now, if the objection continue, you cannot give him the license, then he says that, okay, the
No, now they
municipality has objection. Then
No, now they have, my lord. Process has been.
why on earth did you issue a particular tender in that regard in respect to a particular fair price shop of a liquor shop in that area where the municipality has objection.
Because when the tenders are issued, the the government scrutinizes the area and therefore puts up a tender. In a vast area, he has taken a small pace, Your Lordship. After he being the highest bidder, he has to submit the NOC from the board. If the board doesn't give NOC, he has a provision of shifting. He can shift from that place, Your Lordship. Because in the speaking order, we have already said that he may approach the government for shifting of his license,
Shifting of the,
shifting of his.
Yes, shifting of place.
There's a
But
provision
I
shifting.
don't want, my lord, because your lordship, my condition is, your lordship kindly see, my lord, after 1 year, they have passed that order. Now say, however, he may approach the government for shifting. That is their view, my lord. Process has been, my lord. Now they cannot proceed for license. Now, however, you may proceed, that is the line. So, my lord, I am now, my lord, my health condition is not good. That's why, my lord, I want back the money, my lord.
you ask for that money,
My lord, I asked from the money. My lord. It is a pair, your lordship kindly see.
where the press.
They are in, my lord, in main net petition also they are, my lord. Your lordship kindly see. In main net petition, I have 3 pair I have made. Page 21, my lord. Page 20, my lord. Pair number 1, I have forget now, my lord. Pair number 2. Pair number 3, I am
Direct
skipped.
the year and year without any extra fee and fine. Read the bit. Then- The compensation does not arise.
My lord, only, my lord, money with interest, my lord. Because that is,
Interest, how does it arise?
my lord.
How do you get back the interest?
My lord, they are keeping in the bank, my lord. Probably bank also given to them also.
No, my question is, you participated in the tender.
My lord,
There you are the L1.
L1. And they asked me to
No,
deposit the
wait,
money.
wait. When you are the L1, you are being given this particular contract. You're saying that, okay, you provide these particular details. Along with submit the initial deposit.
Yes.
You submitted the initial deposit, but you couldn't get the objection. No objection.
No.
From the minister, which is also required.
My lord, that is, by law, actually, it is, and it's a tender condition. It's a tender condition, yes, my lord.
So you have to get a no objection. You have failed now.
My lord.
So now you have failed to provide. Then what is mentioned in the tender condition if you fail?
So now, my lord, they says that you shift, agitate the matter before the government for shifting your license, shifting the place. My lord, that is not possible for me at that
It's okay. But my question is, if you fail to submit the necessary documents
My lord,
which are required for the issuance of the license, you have done only one. That is payment of the earnest deposit.
my lord,
But you have failed to provide the no objection. If you have failed to provide the no objection, what is the consequences? They can't issue the license.
my lord.
But can you get the return of the amount? Normally what happens in a tender, if you fail to provide certain detail, what happens? Then obviously some deposit may be reduced or something happens. Let us see the terms and conditions of the tender. Earnest money deposit is based on the location of in the municipal area, the EMD shall be 7. You have deposited 7 lakhs.
No, I am depositing 72 lakhs 300.
Why?
That was, they asked me for, your lordship kindly see the,
Why will they ask for so much?
No, that is the initial grant money, the bid which he has quoted. That's the amount.
Now what happens if you don't give the license?
If he doesn't get the NOC, we give him a provision to shift. If
If
he
he doesn't do
if he
one,
doesn't go, then we cannot do anything else because either we give it to the second highest bidder.
no, you give it, but what happens to his money?
He have to come and ask for
He
speak.
may lose out the earnest money deposit,
Yes.
EMD. But he would otherwise not lose out the other deposit.
Yeah, he have to approach the government stating that
No,
I'm
my
not in
lord, I-
condition to run the license.
Huh?
I'm not in condition to shift or open the license. So I may be, so my bid can be cancelled, your lord. In the way you can approach the authority.
Because if you cancel, just for example, let us see section 31. Even a license is being cancelled. What is the effect? Read section 31. If any license is cancelled under clause B, of subsection 1, the aforesaid authority shall, in addition to remitting the sum as aforesaid, pay to the license such further sum by way of compensation as the government made. Wherever the authority stated in here considered that a license should be cancelled, otherwise then under the provisions of the section, he shall remit a sum equal to the amount of fees payable in respect thereof for 15 days and may cancel the license on the expiry of 15 days of notice in so and so, so and so. Where a license is cancelled under this section, any fee paid in advance or deposit made by the licensee in respect thereof shall be refunded to him, less the amount, if any, due to him. So this is how you do it. Now his cancellation is, let us see section 30. Subject to such restriction as the state government may prescribe, the authority who granted the license, permit or pass under this act may cancel a year if any duty payable, fee payable by the bidder hereof be not paid, if any excisable articles there in the event of any breach of any collar. So these, it is not a cancellation under 30. Now, if it is a cancellation under 31, why I'm saying so? Then you are entitled, you are liable to refund him the fee. No, if that be so, he's only asking for the fee. Here you have not even issued the license.
We have not issued the license
So
yet
therefore, why can't you return him?
because he has not approached the state government stating that I don't want the license.
Yes, sir.
I don't want.
So you want that he should approach,
Yes.
Then
you should
come
approach
back.
No,
the
no, no,
state.
I have
I
already-
don't want to. I don't want to keep the license.
you
Already-
ask them that you want the money back.
No, my lord, yes, your lordship kindly see, my lord. Yes, yes. Page 92, my lord. I have filed one additional affidavit. I have filed an additional affidavit. In that affidavit, I have filed a representation before the government. No, main picture, sir. Page 92. Main petition,
To dispense with the criteria,
page
to
92,
allow me to choose another location. So you have asked that also,
my lord.
to choose another location.
No, that is not possible because of his, my lord, condition. Now he,
So therefore, you need to make this specific, otherwise I am constrained to request you to refund.
He had made two prayers. Give
no,
me
my
a-
lord, I have already I made a prayer, my lord. That is a
May-
page 90, my lord. Page 90.
That is what I'm saying. It's 92.
Page 92, last one. Otherwise, I am constant to request you to refund the last line, very last line of page 92.
Okay, we do one thing. We record his submission. That he gives up his right in respect to the license. And he wants the money back. As per his so and so. And asking you for instructions.
Very well, Lordship. If
My lord. My lord.
that can be.
Or should I dismiss it, then you asking you to submit a report.
No, my lord, that will be, if your lordship give a direction, that will be better because he is now, my lord, his liver cirrhosis, probably he is, my lord, his condition. Because your lordship kindly see, my lord, they are also not interested to do anything, my lord. I have filed,
So
my lord.
we are asking that if you cannot produce
No,
NOC from that place, you
No,
should
my
go
lord,
another
that-
place.
that is
We
a-
have no objection in that.
That is a location, my lord, that is a tender location. They have, my lord, on the,
What do you say, Mr. Gugoi? We have this matter as the last item today.
I'll take that straight. Because in some other, I've come to notice in other.
You are
tender
there till the last end of the day.
matter-
I should not allow Mr. Mohanto to leave on a Saturday so early. Let me tell you last.
actually,
time.
only for this I am coming today, my lord. I am also not good, my lord. I am suffering from cold, my lord.
See,
Only for this item I am coming, my lord.
because he's suffering from cold, he's doing a liquor license. That too on a Saturday. Huh? Yes. Why are you objecting? The petitioner herein have approached this court challenging the decision of the Polasbari Municipal Board whereby the no objection so sought for by the petitioner was rejected. And further, sought directions that the respondent authority to issue the IMFL off license to the petitioner. It is also seen from a perusal of the writ petition that the petitioner had also made an alternative prayer that the respondent authority shall return the deposited initial grant bid to the petitioner along with interest and compensation. Mr. T.J. Mohanto, the learned senior counsel, assisted by so-and-so, submitted on instructions that the petitioner does not want to further press on the reliefs as stated in Roman 1 and Roman 2
My lord.
of the writ petition. However, the petitioner, taking into account that there would be difficulty in getting a location, seeks return of the deposited initial grant money, grant B, along with interest. Mr. Mohanto further submitted that the petitioner also would not insist on the compensation. Mr. R.R. Gogoi, the learned standing counsel of the Excise Department, shall take appropriate instructions in view of the submissions made by, in view of the concessions given by the petitioner as regards giving up the reliefs at serial number Roman 1 and Roman 2 of the writ petition, and place the appropriate instructions before the court. List the matter on 17th of November 2025.
Oblex.
In that earlier matter, my lord, just now I did talk, my lord. He's in abroad, my lord. He's in abroad, my lord.
Huh?
He's in abroad, my lord. He's in Indonesia. He'll be coming on 8th, my lord. Can it be taken after 8th, 10th or any other day, my lord? That's the problem. Just I did talk 10 minutes back, my lord. That is
So
the.
you could talk to me.
Yes.
Now they did say to you that he has a,
Well, he has to, he told me to have to go through the record. Now he's in abroad, my lord. That is the.
he's
Lordship,
not
can I
running
take
the
up after
college.
8th, my lord? Any day after 8th, my lord.
No, 2 o'clock.
My lord, 2 o'clock.
2 o'clock. We'll have it at 2 o'clock. Then we'll see, consider your request.
My lord.
Other side are not here. No,
My lord, I will inform Mr. Chaudhary,
No,
my lord, if
I'm
your
not-
lordship.
I'm not going to.
I've just convey my income.
Mr. Host, there is a decorum. The decorum is.
I
at
understood,
6
my lord. I
o'clock,
understood. That is I said.
You make that submission.
My
at
lord,
2.
I,
And
lordship.
when then I may consider or pass the judgment, which I don't incline
My lord,
to.
my lord.
I think people are losing. Now he has to give money back to Mr. Mohanto.
Yes, my.
Unless he gets the money from the petitioner in that case. Or from where will the excise department give?
That is I have
We
convey
will
my
have it
lord.
at 2, we'll consider. that.
Lordship. I am deeply obliged,
Now.
lordship.
Said that there was a work order issued by PHE. Thereafter, PHE gave a letter to us, asking us to make the payment. The issue is that ATDC has no knowledge of this work order. Neither they have ever floated a tender because ATDC has to work through the e-procurement system. And we have not floated any kind of tender, so we do not know about this work order. If I may take your lordship to the petition draft, the writ petition filed by the petitioner. If your lordship sees in annexure 2, page 12. They give a completion certificate, your lordship. Lordship has the document. Lordship, they give a completion certificate. They say that they had the date of commencement of the work is 25/12/2022. That is point number 8. And thereafter, point number 9 talks about the date of completion 31/12/2022. Then they say if your lordship goes to number 5, that's tender number NIT 01 of 2023-2024. Now we have no knowledge of what they are talking about because neither we have given this completion certificate nor we have ever floated a tender like this. And also, if your lordship goes to the writ petition, lordship would see that the work was completed in 31/12/2022, but the work order was issued in 2023 November, after a year. So there is a lot of confusions and there is also a lot of disputed questions of fact and law in this case, your lordship. We have filed a referendum of opposition in, when did we file the referendum of opposition? 22nd July itself on 3/9/2025, PHE was, because it is a case of PHE who has given, apparently has given the word order. So we cannot answer much in this because we do not know about it. Although we have been asked to pay the money.
You are paying for?
I'm appearing for Assam Tourism, which is R4. That's 1/4.
What about this communication at page 11? It is marked to you?
Yes, your lordship, it has been marked to us, but we have received it, but we didn't know what is it. We didn't know, we didn't understand what was there, what was all, it was because we had never issued any work
You
order.
write it, write
Yes,
back?
your lordship, that I have to ask them because I do not know whether we wrote back, but what the instruction that I have, your lordship, they said that they did not, they received this, but they do not know about it. So they were also confused when they got this. So I think the PHA is the appropriate authority who can answer this, whether they issued a work order like this, and if they issued, why was the buck passed on to ATDC to make the payment, because we do not know about it.
Lordship, they have filed an affidavit stating that they have no knowledge about this work order issued. So this affidavit, today I've taken a copy for them. I'll send this affidavit to the authorities seeking clarification on the statements made here in Lordship. Because we have
The
to,
problem is with your executive engineers.
yes, sir, Lordship.
They are doing whatever they feel like. I'm having a matter on 11th or 12th. Huh? I'm asking the
This on this commission secretary. Yes,
to
yes,
be
yes.
present to video call.
Yes, sir, Lordship.
Because they are creating a lot of problems. These executive engineers here, PWD everywhere, they, whatever they feel like they are
Doing
doing.
it, Lordship. We have
Huh?
listened. True.
And you, in your affidavit, also have to assert it. Who is this particular person who has issued this work order? Because why I'm saying so, the completion certificate is given no date,
True.
but it says the date of completion is 31/12/2022. And the work order was issued on 29/11/2023. And the NIT number 1 of 2023-24 has to be during the financial year 2023-24. Then how can it be completed on 31/12
Exactly. 31 to 22.
unless and until this is a forced document?
Exactly.
Maybe this Annexure 1 may have been issued, but Annexure 2 appears to be forced document. Find it out, because this is very serious. And these executive engineers are creating a lot of problems. I think you should divest them from all this. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Miss P. Borwa appears on behalf of the Assam Tourism Development Corporation. And Mr. R.R. Goi appears on behalf of the PHED. The petitioner has filed the instant writ petition being aggrieved by the actions on the part of the respondent authorities in not making payment of an amount of rupees 39,145 265, which the petitioner claims to be due on the basis of the work completed pursuant to the work order dated 29/11/2023. It however surprises this court to take note of the work completion certificate, wherein there is a reference to an NIT number. The reference to a tender number being NIT number 1/2023-24. And the work has been shown to have been completed on 30/12/2022. But the work order, which is Annexure 1 to the petition, was issued on 29/11/2023. Ms. People were appearing on behalf of the respondent number 4 submits and that an affidavit has been filed, wherein the respondent number 4 has completely denied that upon their instructions, any such notice inviting tender was issued or any work was done on behalf of the petitioner. Mr. R. Gugoi have been furnished a copy of the affidavit in opposition. And he submits that he would obtain instructions and file an affidavit. Accordingly, list this matter again on 19th of November 2025. In the meantime, the affidavit be filed on behalf of the PhD by 17th of November 2025. And in the said affidavit, the petition respondent PhD shall also indicate as regards the discrepancy in Annexure 1 and Annexure 2 to the petition and why the executive engineer PhD Guwahati division had issued such a completion certificate which appears to be backdated. List accordingly.
Item 7 and 8.
Mayor, Your Lordship. Also, the matter relates to non-payment of hire charge bill, Lordship. Now, the authority has filed affidavit stating that they have scrutinized the bills, and now the authority has filed affidavit stating that the bills have been scrutinized, and it is, Lordship, forwarded for its approval. Now, whether the approval has been given or not, that is not stated, Lord.
Paragraph 7(6) of the affidavit you duly acknowledge 3182. Madam,
Yes, madam. Yes, paragraph.
what is the
6 of-
claim of the petitioner?
Yes, paragraph 6 of the petition 3400, madam, 7, item serial number 7. Here, madam, that committed amount is 31,82,138. Paragraph 6, madam.
So pay within 6 months.
And this matter.
It will have a police order to do. And in the second also affidavit
Second.
filed.
Affidavit filed.
Madam. Here we have categorically stated regarding my lot 9 lakhs 30,000 at page 62. In paragraph 5, continuation of paragraph 5, and at page 62, my lot, we have admitted that my lot 9 lakhs 30,160 have been received and amount will be credited to the bank account. But as per my learned friend's instruction,
Not credited.
petitioner has not received yet, my lord. And the remaining amount, my lord,
So as of now, how much amount? 22.
No, Lordship, the total in the second case, my claim is for
this claim is for 40,000.
41 38,022.
4137,
Lordship.
whereas the actual payable was 41. However, on scrutiny of available, it is found the petitioner has submitted a one-time settlement declaration certificate to the concerned authority for deduction of 20% from the high charges against 9 numbers of charge bills out of the 25. Accordingly, these bills were deducted by 25 per time from the so-and-so and forwarded to the police. So this is with deduction of 20%, so these. It further stated that the finance against the proposal for rupees 6 lakh
Total 9 lakh.
and amounting to rupees have been received and the amount will be credited to the bank.
This
It is also stated that the financial sanction against the two amount of AR is yet to be received. Further to that, it is stated the remaining 62 IBAN amounting AR were scrutinized with the available records and after completion of the required so and so approval for sanction. So what is being now doing is 9 lakhs plus
22 to 5.
and 22.
According to them, altogether 31 lakhs, I have calculated 31 lakhs 55,972. According to them, this is the admitted amount, although my claim was for 41 lakhs 38,000.
41 lakh, but there is a deduction of by 20%.
Yes, Lordship.
So you have to pay, get only that only. Itu put koi দিব দেই, এই পুলিশৰ পিছত আমি put কৰি দিম না। এইটো আগৰটো সেই paragraph 6, ইয়াত paragraph 5. Put কৰি, the total amount admitted is 31 lakhs.
total.
31,55,972
You just pay within 6 months.
in item number 8. In item number 8. This amount is for item number 8.
Both disposed.
Lord.
পুলিশৰ নিচিনা DGP people.
All right, Lord.
Supplementary item 18 to
Within a
20.
within a time from Lord.
6 months.
Of Lord.
Yes, what is this? That they have made up this matter. Kostok Gogoi, instruction, Zakir Hussain.
Yes.
Oh, this one, the.
Madam,
Yes, where is Mr. Aibot Thakur?
I'm read to your lordship directed me to obtain instruction from Commissioner and Secretary Malak. But as per, I have received the letter, but it's a WhatsApp and it will be a data. So I asked him to give a scan copy, so it will take some time. So there, Malak, they have mentioned that it is Malak, the district authority will have to send a fresh proposal because now already saturated and no more EPOS device can be given to any new. Otherwise, someone will have to withdraw or someone has to die or something, then only it can be given. So maybe taken up after some time so that I can produce the letter issued by Malak. Otherwise, it would have been wrong on my part, because they cannot exceed the total amount of EPOS device sanctioned to the district authority. Number of
Post device, they cannot, but the fact remains that he was granted a fair price shop.
Mine.
So when his 5 plus license is in existence,
Some
and
facts-
because of the fact that you are not in a position to give the EPOS device, then cannot disentitle him. He has a right.
Malak,
Either you cancel it, the license, but you cannot deprive him from the functioning on the ground that there is no EPOS device.
Malak. So
Yes.
that's a fact that that's why in affidavit, though it has come, but without the paragraph of that phone number of the department. So I could not find it yesterday. I'll have to get a fresh one, affidavit. There's some facts are also mentioned in the affidavit. So anyway, I'll produce it the later at 2 o'clock.
You want to file the affidavit?
By the district authority, as yesterday I had so many mentioned that I have received the affidavit, but without the paragraph of phone number, dependent being there. So anyway,
Okay, we have it on next Wednesday.
Next one.
Oh, Wednesday, next Friday,
Right.
next Thursday. Can you file your affidavit in the meantime?
Not because from Dhubri, it's difficult. I'll try and get it by
He has not signed it.
He has signed it, but the paragraph now, it is required to add the phone number. Opponent's phone number is required, and then when we can be contacted. Get the FedEx. I'll try to get it.
Ms. Yudas, the learned additional senior government advocate submits that she has received certain instructions. And the affidavit is also ready to be filed. However, on account of the deponent being not available today, the affidavit could not be filed. She submits that the affidavit will be filed within a week's time. List this matter again on 17th of on 10th of November. 10 days. Then how much do I give you? 12. 12.
I'll file the affidavit by, from by, estimate number 1 also, he has taken his.
Okay, by 12. 12.
By 1 and.
Listed again on 12th of November, the affidavit be filed on or before 11th of November.
21 and 22.
Oh, this one. What is that?
In fact, my lord,
Has the ground floor been demolished?
My instruction demolished now.
Where is that, Mr. Sanjay Sharma?
Petitioner is-
but
But
one
he has
aspect
got
of,
disheartened yesterday, the
No.
day before yesterday when I said that he is no longer representing now. And where is the lawyer for that person? There was a lawyer who was representing him,
In fact,
No,
he is also a resident of that same building, that lawyer.
the lawyer.
Yes.
in fact, may I draw your lordship attention, my lord, regarding that ground floor, my lord. As per my instruction, yes, there is a room still exists, and we are going to demolish that the room also, my lord. The occupants are the rooms, the tenant, they are at present not at Guwahati. We'll intimate them. The goods of those their particular articles will be removed. Then we'll demolish that room.
No, no, no. I think you should demolish it. We don't trust this.
Mayor Sabin, Lordship will take up this matter on Tuesday, Lordship. We'll give your Lordship a very clear picture, Lordship, with photographs, Lordship. Even today, GMC persons are there.
No, this matter every day I'm taking up, nothing is.
Lordship,
See,
this,
Mr. Gusami,
Hello.
this court, you want this court to consider on the third
Malo,
floor.
malo.
You have to be more, come up more before this court with a clean hands and all.
Malo.
On one hand, you are saying that we are going to demolish, it is not happening, it doesn't.
Lordship, in fact.
No, we fourth floor, we demolished.
Third floor also. It was in the undertaking, it was clearly stated that we are going to demolish third and fourth plus the ground floor. But subsequently, another court gives then some protection, so far as the third floor is concerned.
But regarding the ground floor, it was initially that the GMC authority has demolished it. Units.
Except that room behind that.
Since the room is exists, as your losses query, put a query on day for yesterday to me, Malad, I verify, yes, it is there, and we'll demolish it, Malad. We'll undertake to demolish it, Malad.
But that,
Mr. Gusami, what you are asking before this court is a mercy.
Malad, definitely. I admit,
When you
Malad.
are asking this court about the mercy,
Malad.
you have to come up with reasons. You cannot try to come up with that we are going to do this, do that. You have to come up forthright and say that look here. The first floor, the fourth floor, we have already demolished.
Malad.
And the ground floor, we have already demolished. Then we can consider taking
Malad.
into account. There is a rule.
We'll
of
clear
the-
that
amongst the
question also.
Guwahati High Court, Guwahati, the DMC bylaw, building bylaw,
Malad.
that if a building is otherwise okay,
Malad.
and it is not required to be demolished, it is not unsafe, the GMC may consider to
Malad.
that effect. So there is a rule out there to that effect.
Malad.
So we may urge the GMC to consider taking into account that the ground floor is there and the ground plus 3 is otherwise permitted. There might be, they may consider to that effect.
but
No.
to that effect also, Lord, if it is the occupant who is residing in the third floor, they will approach this honorable court, not the petitioner. Because he has already sold the building.
So
He is
Not-
not the owner of the building.
Not,
He
not
is
at,
the builder.
all the units are not sold out. In some portion of the units are still in my position. Malad.
floor, I'm saying about third.
Third floor is 70% tin, Malad. roof is tin. Only 30% is RCC, the third floor. That is the actual position, my lord.
Third floor is
My lord, 70% of the Malot area is tin, Malot. Is a tin
so
roof.
what did
And
you construct on the
30%
fourth
is
floor?
Pakka roof.
And
As per
what was constructed on the fourth floor then?
fourth floor is the overhead, there is Malot, the water tank and units was there, Malot. That has already been, the unit has already been Malot dismantled, as you all says.
No, that is why now I get the point. Why these people are agreeing. The moment you are making a tin construction out there, they lose the right of roof.
Malot, the roof is there, 30% portion of
What
the roof is there,
30%
Malot.
of roof? It was ground plus 2.
Malot,
Then there was a proper roof.
Malot,
They're losing the right of the roof
Malot,
with that construction of the third floor.
Malot.
You have to demolish. This can't happen like that. If you had the roof, the entire roof, it could have been considered. They have a life to that effect. Okay. And who are you? You have already done, made every construction, give it to others, and now you are doing it. You don't have the locals. Let these people take over the action. And have these people purchased it, the third floor?
If they have lots, somebody is occupying the third floor. If they are that owner of that building purchasing from the builder lordship, if somebody has to approach this court lordship, that the occupants, not the petitioner, not the builder.
No, occupancy is different from the owner.
No, because ultimately they are going to be affected. Lord.
If he continues to be the owner, then obviously he will have a right.
He cannot be the owner, Lord. Permission was for ground plus 2. Ground plus 2 has already been sold. That third floor is unauthorized construction. Fourth floor unauthorized
So
construction.
third floor, he could not have sold it.
Yes, definitely.
He have not sold it.
But somebody he has already
So
sold.
if he has not
Malot,
sold it,
as-
he becomes the owner.
If somebody purchased in the meantime.
Whatever,
Construction may
he
be
is the owner.
construction, even if construction is unauthorized, if somebody had in the meantime purchased that portion lot, he became the owner, new owner. He is going to be affected if it is.
Have you issued
and you will
notice?
approach-
Have you issued notice to those?
Notice was issued to him, not.
No, issue notice upon these people. That it, in view of these matters and all, there is nothing out there, to that effect, it will be demolished. Giving them notice, let them.
The understanding is that lordship, if the permission was for ground plus 2, capacity was for ground plus 2. If one more floor is constructed, that will definitely make the building unsafe, lordship.
No,
If the
Malot.
plea
No,
is for
that was,
ground
that
plus
was not exactly position, Malot here. Malot, the construction at the time of Malot obtaining NOC in the building instruction, that is Annex 4 of the first writ petition, Malot. The construction is, there is no deviation, Malot. The construction is for G plus 3, Malot. But the GNC authority approved only G plus 2. The construction, as per that diagram, it was constructed, Malot.
What is this? Annex 4 P2?
Malot. Malot, here it was by approved by one of the retired Malot GMC engineer, Malot. Malot, it was made for Z plus 3, but the
Not
GMC authority,
Basement.
Malot,
One is-
without deviation of the construction, the structure, Malot, the GMC approved for Z plus 2.
No, here it is not basement, it is ground floor is parking.
Lordship, what actually is there, no basement is there, but the approval was for basement plus ground plus 2. He constructed the ground and the 2. And the ground floor has been, are being used as a parking.
No,
Initially the-
kindly come to Annex P3. Page 28. Number of floors, ground floor, first floor, second floor.
Yes.
GF parking.
Basement is not, the
There is no
ground,
basement.
no, in
There's
the
no
drawing a basement is there.
Huh?
In the drawing, Lordship will see one basement.
Where? There is no basement. It is ground floor plus first, second, third. And it has been shown as approved on the right hand side.
Yes.
So annexure P2 is approved. This is the approved plan.
Lordship, so far as notice is concerned, Lordship 337-1, the building was inspected and measured by Zonal Engineer Guwahati Municipal Corporation on 21/10/2024.
Now kindly come to annexure P2.
Ground floor, first floor and second floor.
Yeah.
Ground floor is 40.
Ground floor is parking.
Yes,
First floor and second floor.
yes.
And this must have been given as per some far floor area ratio.
Yes.
So ground floor is totally, there's no basement out there.
In the drawing initially it was there. That is why that deviation comes from.
No,
here.
where is the drawing in this drawing? You see, clean, earth, plate, RCC bed, floor finishing, that till there. Then ground floor is parking, first floor, second floor. And above that,
If
there
Lordship
is a
comes to
cross mark.
P2, page 27.
Page 27, if you see,
Or
on top,
first
it's,
floor.
it is crossed.
First block, it is, it has been crossed.
Cross.
No,
So this is not permitted.
no, Lordship is ground is a
Parking.
parking, complete parking, yes,
Ground is parking first and second.
yes,
So he should have constructed in that ground and first and second.
yes,
And top floor was not permitted.
not true.
So this was without the permission. Okay? And how can you compound? You can compound up till, you see, there is no question of seeking anything. You can compound. The compound is, flooring is not compoundable, isn't it, Mr.?
Not compoundable.
Flooring is not compoundable.
Additional floor is not.
Additional floor is not compoundable. How do you do it? So we dismiss your petition.
We
And now
actually,
we
Malot, for
petition.
Malot, pursuing the matter for the authority,
This court
admittedly,
should
the
be
appeal was
taken,
given,
I-
Malot rejected.
Take up
Then
a-
we approached the authority with a review application, Malot. It is still lying with the authority. We
Review? What review?
review against the Malot appeal order, Malot. We prefer the application for review, GMC's authority, GMC authority for review their
Where's the
decision.
provision for review?
Was a review may Malot take up Malot by the GMC and Malot.
Never heard of. No review business. You should be demolished and take out the money from him. Demolish. You have issued notice to him.
Yes.
Okay.
Notice is there,
And he knows,
demolition order is also there.
and if I'm not wrong, if a flat is being sold, you have need to take permission, or did he sell the flat during that period when there was no requirement? There was a period, na, for selling of flats, you didn't require permission. For a few days, on account of an amendment being made, which was subsequently changed, na.
Not.
Remember
Yes.
that there was a proviso being put in section 21A. And then that proviso was again changed, removed by another amendment.
Not.
So we dismiss it. Do whatever you feel like. But we keep Mr. Sanjay Sharma's case alive. Because there has been not, it has not come to an end. Because there is still construction remaining.
In the ground floor.
Yeah.
But
So
that report I'm
you
furnished.
produce it on Tuesday. In the meantime, let us dismiss his petition.
But as a last chance, we are going to not.
But what about the third floor? How on earth can you do anything?
Malot.
You constructed, because if we give anything out here, it would be opening floodgates for everybody. Isn't it?
Yeah. That may create difficulty. I will remain as a prisoner.
So we'll remove the ground floor room, my lord. Let it be remain on
Third floor. Third floor.
first floor. We, as you, let's say I apprised before, let's say we pursue for the GMC authority.
No,
It is lying since the, Malad, let it be on Tuesday, Malad, so that Malad Yolos is finally decide the.
the sad
two
part
matters.
is I am here for this in this bench.
No,
sad
let it,
part-
let it be
no,
remain
no,
on
the
Tuesday,
sad
Malad.
part
On
is
that
it-
day, Yolos is
earlier-
take a decision, Malad.
earlier you
Till
got a
then,
very
Malad,
good-
we'll
very
remove
good
the ground
judge
floor,
who
Malad.
passed the stay order on 29th. Anyway, let us first, we do one thing, we vacate this interim order first. First, we vacate this interim.
Let it remain on there till
No,
Tuesday.
no,
You'll see losses since taken up the both the matter together, Malad.
No, that I'm taking up. Heard Mr. U.K. Goswami, the learned counsel for the petitioner, and Mr. P. Naik, the learned standing counsel of the GMC. Mr. P. Naik, the learned counsel, submits that from a very perusal of the enclosures to the writ petition, it is apparently clear that the petitioner was not granted any permission to construct on the third floor. Referring to annexure P2 and P3 to the writ petition, the learned standing counsel of the GMC submitted that the petitioner had violated all norms and not only constructed the third floor, but also the first floor, fourth floor. It is under such circumstances, the GMC authorities have taken steps for the purpose of demolishing the ground, steps by passing appropriate orders for demolishing the third and the fourth floor, as well as the construction so made on the ground floor, which was specifically earmarked for parking. Mr. P. Naik further, referring to the judgment, recent judgment of the Supreme Court in the case of Tanis Ahmed versus Sabuddin, SAPUTTIN, and others reported in 2025 INSC 610. Referred to paragraph numbers, which was the paragraph 6 and 7. Huh?
6 and 7.
6 and 7, and submitted to this, and submitted that the Supreme Court has been categorical in observing that if a person have constructed a building unauthorizedly, he is not entitled to regularization, isn't that?
Yes.
This court have duly taken note of the judgment of the Supreme Court in the case of so and so, and have also further taken note of paragraph number 6 and 7, which is reproduced here in under. From the above paragraphs, it is very clear that the petitioner hearing, the petitioner from the above paragraphs, from the principles laid down in the above two paragraphs, above two quoted paragraphs, as well as and the same being applied to the facts of the case, could show that the petitioner herein is not entitled to any regularization of the third floor. Considering the above, it is therefore the opinion of the court that the interim order passed on 29/8/2025 cannot be further extended as it go against the settled principles of law, for which the interim order passed on 29/8/2025 and the subsequent extension are vacated. The respondents in the GMC would be at liberty to take appropriate action as per law. List this matter along with WPC number 4562/2024, again on 11th of November 2025, on which day the GMC authorities shall give an update as to what is the present status of the demolition. You could therefore list this matter along with so and so on so and so.
23.
If he lordship, as per my lord's direction, I have gone to the provision lordship. After 18th lordship, my operation of law was.
So therefore, I think we should reconsider.
I don't know how to any lordship.
So you have to reconsider because he has got the approval and he continues to remain the same. You may have to enter into, if they already a contract, you may have to enter into a fresh only for the purpose of making payments. Because his bank account number, name will change now. That is the only reason. So therefore, in view of the rule section 18(3), read with so and so, he should, the authorities should reconsider this decision.
I will not.
To allow your petition in there, not to give you, to reconsider. They will reconsider in view of this. I can't give it to you. Therefore, I'll set aside that, the decision, and direct them to reconsider in view of this.
But setting aside.
Okay, Mr. S. Sharma, first up will be done.
Indicated that report.
Eh?
The indicator that 430.
4:30, na?
My entrepreneur so very was afraid.
Mr. S. Sharma, the learned counsel appearing on behalf of the petitioner. And Mr. K. Gogoi, the learned counsel who represents the respondent number 120. The petitioner hearing is agreed by the order dated 3/9/2025, whereby the respondent authorities have cancelled the letter of intent and terminated the contract on the ground that the bank guarantee which was submitted by the petitioner could not have been taken into consideration in as much as the contract was awarded to RV Associates, Architects, Engineers and Consultants Private Limited in consortium with Prabhavi, and the said RV Associates, Architects, Engineers and Consultants Private Limited did not provide the bank guarantee, but rather the bank guarantee was provided by the petitioner. The issue involved in the present petition is a legal issue as regards the effect of a change in the name and the class of a company in respect to contracts entered into. Contracts entered into. For the purpose of deciding the said issue, this court finds it relevant to take note of certain the brief facts which led to the filing of the present petition. The petitioner number is a company, is a limited company registered under the provisions of the Companies Act 2013.
Earlier, 1956, now.
Now it is registered
No,
2013. Having its registered office at 8-2-5 Ravula Residency, Srinagar Colony, Main Road, Hyderabad, 82. The respondent authority had issued a notice inviting tender for appointment of, had issued a request for proposal for appointment of general consultant bracket GC for the Northeast Frontier Railway headquarters. In terms with the said RFP, the bid due date and time was 1400 hours on 24-10-2024. And the bid was to be opened on 15:30 hours on 24/10/2024. Petitioner, the RV Associates Architects, Engineers and Consultants Private Limited which was a company registered under the provisions of the Companies Act 1956, participated in the said bid process by submitting the bid on, when did you submit the bid?
Was submitted on 5/11/24.
5/11/2000, huh? It was extended.
5/11/24 first bid, then subsequently negotiated bid was submitted on 26/5/25.
No. No, it was extended. The bid due date was extended. The bid due date was extended.
No, not extended.
100% it has to be extended.
Maybe it might have been.
It has been stated at the bar that the bid due date thereupon was extended and RV Associates, Architects, Engineers and Consultants Private Limited, along with other bidder, submitted the bids on 5/11/2024. Along with one Prabhavi submitted the bid. RV Associates so and so in consortium with Prabhavi submitted the bid on 5/11/2024. As a joint venture. The record reveals that in the meantime, the company, namely RV Associates, Architects, Engineers and Consultants Private Limited, with the approval of the central government, changed the name to RV Engineering Consultants Private Limited. And thereupon, the class of the said company from private limited to limited company was accorded by the Register of Companies, CPC, by an order dated 4/2/2025, and the company was formally was named as RV Engineering Consultants Limited. In that regard, a certificate of incorporation consequent upon conversion to public company was issued by the Ministry of Corporate Affairs on 16/2/2025. Pus- Mr. Sharma, you informed this aspect somewhere, some letter I remember. This one, 449, na? Prior to that, 49 also you informed.
Is 5/5/25, and next year 14, NJ 14. And page 82. Page 82, my brother.
The petitioner, thereupon taking into consideration that the respondent authorities were still evaluating the tender so submitted by the joint venture of RV Engineering Consultants, RV Associates Architects, Engineers and Consultants Private Limited, in consortium with Prabhavi, intimated about this change, this development, by the communication dated 6 or 5, 5/5/2025 to the respondent authorities, thereby enclosing the certificate of incorporation pursuant to conversion, PAN card and 10 card, and 10, PAN card and 10.
UC175.
Hmm?
UC175. UC175.
The record further reveals, more particularly the communication dated 5/5/2025 was received by the respondent authorities on 7/5/2025. The respondent authorities, however, now it seems that the respondent authorities, however, did not give any importance to the said communication dated 5/5/2025 and issued the letter of acceptance in the name of MSRV Associates, Architects, Engineers and Consultants Private Limited in consortium with Prabhavi, rather than issuing the letter of acceptance in the name of the petitioner in consortium with Prabhavi. In terms with the said letter of acceptance, the petitioner was required, the bidder was required to submit a performance guarantee in the form given in clause 2.15 of RFP tender document, equivalent to 5% of the contract value, amounting to 1,83,00,000 1,956.85% and 85 paise. Within 15 days from the date of issuance of the letter of acceptance, valid up to the stipulated date of completion, plus 60 days so that the contract agreement can be executed. It was further the stipulation contained in clause 2.15 that if the letter of acceptance, the earnest performance guarantee is submitted within a period of 60 days, there won't be any interest.
It is 60 days, they will charge interest.
After 60 days, they would, na? Of clause 2.15 of the RPF.
One page 83 in between, page 83, I don't know time. Page 83 in between.
83.
83. On negotiation part in the name of new company.
Huh?
Page 83.
86. This was subsequently given, na?
Page 83.
83.
Page 83. Before LOA also negotiation in the name of new company. Page 83 also.
That is also relevant. They have called us for negotiation in new name.
It is on.
In your company, in the name of the petition.
In a
na?
new petition,
It is on.
and accordingly,
It is on 22/5/2025 also before issuance of LOA also.
Tick, I'll put.
Also.
and accordingly,
Now, what is this stipulation of within 60 days without interest and after there is an interest? You know, there is a given one. Huh?
after 15 days, up to 15 days, no interest. After 15 days, they will charge interest.
There's a term out there where it is.
But that is.
2 point.
So this is, my lord, page 111, my lord. Page
Huh?
2.1.5.1.
2 point.
2.15.1.
2.1.
2.1.1.
Where? Page?
110 and 111 of my petition, man.
2 point. 2 point. 2.1. Thank you. 2.15 of the request for the proposal that if the performance security is deposited within 60 days, there shall be no interest. However, if it is done beyond 60 days of the issuance of the letter of acceptance, 15% interest per annum shall be payable by the selected bidder for the period of extension beyond the days mentioned in the kit. It is the further stipulation in clause 2.1.5.1 that if the performance security is not deposited even up to 60 days from the date of issuance of the LOA, no, again. As per clause 2.1.5 of the RPF document. At this stage, this court finds it, at this stage, this court finds it pertinent to take note of clause 2.15 of the request for proposal. The said clause having relevance is reproduced herein under page 110 of. Let me come back. Anybody else have other important matters? See?
Number 11, Lordship.
11, na? After this.
One thing, my lord, I would like to clarify, my lord.
A perusal of the above quoted provision would show that the selected bidder is required to submit the performance security to the authority to the sum equivalent as mentioned in the kit, KIT. There is a further provision for granting an extension of time for submission of the performance security beyond such day and up to 60 days from the issuance of the letter of acceptance. On the basis of a written request given by the selected bidder. In such circumstances, an interest at the rate of 15% per annum on the amount of security, performance security shall be payable by the selected bidder for the period of extension beyond the day mentioned in the kit. It is further mentioned, stipulated, that if the selected bidder fails to submit the performance security even after the 60 days from the date of issuance of the letter of acceptance, the contract shall be terminated by cancellation of the letter of acceptance and an amount of the bid security shall be forfeited. Full stop. Proceeding further, it will be seen from the impugned order itself eight,
24.
eight,
84 and 85 also.
84. What is where is the impugned order?
Hello?
Impugned order, where is it?
It is page number 84.
84.
84.
That the petitioner where are the letters given for extension? Where are the letters given for extension?
My lord. Page number 25 and 26, my lord.
No, no, no. They have given you these letters, no?
Or their letter. Then it is our letter. It is our letter seeking extension. And
It
their
is seen from the impugned order itself. Did you ask for extension?
my lord.
Did you ask for extension?
Yes,
Where is your extension?
my lord. Page number 26. Page number 25 and 26 are the two letters requesting for extension, my lord.
It is seen from the materials on report. More particularly, Annexure 3 and Annexure 4. That the petitioner sought for extension for submission of the performance bank guarantee. However, the respondent authorities permitted. However, it is seen from the impugned order itself. There are the respondent authorities granted time to MS RV Associates Architects, Engineers and Consultants Private Limited in consortium with Prabhavi bracket joint venture to submit the performance guarantee. The records further reveal that the petitioner submitted the performance guarantee on, where's the date, where's the performance guarantee?
On 23/7.
Page
Page 28, my lord, which were received by them on 25/7. Page 28.
performance guarantee on 23/7/2025.
Receipt by them 25.
in the form of a bank guarantee issued by the ICICI Bank Limited of an amount of rupees 183,01,957. This court have further perused the said bank guarantee submitted by the petitioner wherein it has been duly mentioned that a letter of acceptance, that the contract was awarded to the petitioner, formerly known as RD Associates Architects, Engineers and Consultants Private Limited, in consortium with MS Prabhavi. And the ICICI Bank Limited guaranteed and undertook to pay to the client in full without any deductions set up or counterclaim whatsoever. The sum claimed by the client, which shall not exceed rupees 1,83,01,957 at any time up to 28/2/2029 without any demur, reservation, contest, recourse or protest, and or without any reference to or inquiry from the GC. The said bank guarantee was duly accepted by the respondent authorities, received by the respondent authorities on 25/7/2025. On 28/7/2025. The impugn order further shows that the respondent authority informed the petitioner that the name of the selected bidder was not matching with the name mentioned in the name of the bidder, and informed that the performance guarantee so submitted was not matching with the name mentioned in the letter of acceptance. And in response thereto, the petitioner duly submitted email on 29/7/2025 and in response, the petitioner duly issued email about the official change of the name of the selected bidder from RV Associates Architects Engineers and Consultants Private Limited in consortium with Prabhavi to RV Engineering Consultants Limited. It further appeared that the respondent authorities thereupon being not satisfied had issued the impugned order, thereby cancelling the contract in favor of the petitioner. And forfeiting the bid security of an amount of rupees 100, by the impugned order dated 3/9/2025. It is under such circumstances the present petition has been filed.
Regarding extension part also, kindly use paragraph 3 of the letter also. And that was also our in the application also. That underlying portion, other although required under clause so and so, but no extension was sought by the authority.
No. That is why I say, no, he sought for extension. But as per you, the extension was not sought for by that consultant. Therefore, you gave him time till 21/7. It is not that he did not ask, he asked, but you did not recognize it. If you see paragraph page 23, 25, he asked that kindly give me some more time for submitting the performance guarantee.
Yeah, there was no sin.
But he acts as RV engineering consultants. But you gave extension on 21/7. But you gave extension in the name of RV Associates Engineer. So that is what I say. It may not also be out of place to mention that the petitioner had also submitted a representation on 4/9/2025, which however did not find any favor from the respondents. Next. Upon the petition being filed, this court issued notice via an order dated 19/9/2025 but no interim order was passed with an observation that any new tender, if floated, shall be subject to the outcome of the petition. It was further observed by this court that in the meantime, if any new tender process is floated, the petitioner can participate without prejudice to the rights and contentions made in the petition. The respondents pursuant thereto filed a detailed affidavit Wherein it was mentioned that the bids were submitted by the petitioner. Bids were submitted. Was a bid submitted by a joint venture of MSRB Associates, Architects, Engineers and Consultants Private Limited in consortium with MS Prabhabi. And the letter of acceptance was issued to the said joint venture on the basis of the joint bidding agreement. It was further mentioned that the petitioner could not be said to be the lead member, taking into account that the joint bidding agreement, that neither any joint bidding agreement nor any modified joint bidding agreement to that effect was submitted by the selected bidder. It was further mentioned that the petitioner did not, it was further mentioned that no extension of time for submission of performance or performance guarantee was submitted either by the selected bidder or the authorized representatives of MSRV Associates, Architects, Engineers and Consultants Private Limited, which was the lead member. It was further mentioned that there was no denial of the fact that the respondent authority duly received the bank guarantee on 28/7/2025. And immediately the selected bidder was requested by letter dated 29/7/2025 to submit the corrected bank guarantee in the name of the selected bidder. In the said affidavit in opposition, reference was made to clause 2.1.2 Roman 6 C of the request RFP, wherein it is stipulated that there shall be no amendment to the joint bidding agreement without the prior consent of the authority. In addition to that, as per clause 2.1.2 Romans 7, there shall be no change in composition of the consortium would be submitted to the authority during the selection process and during the subsistence of the project. It was this contention of the respondents in their affidavit that the performance bank guarantee was not submitted by the joint venture of MSRV Associate Architects, Engineers and Consultants Private Limited in consortium with MS Prabhabi, but rather the performance bank guarantee was only submitted by MSRV Engineering Consultants Limited, which was a different entity. And it was therefore the contention that in terms with clause 2.5.1 of the RFP, the termination letter issued on 3/9/2025 was as per the terms and conditions of the RFP. The petitioner, pursuant to the said affidavit in opposition, the petitioner submitted a reply wherein, apart from repeating and reaffirming the statements made in the petition, it was stated that the respondent authorities who very well knew about the change in the about the change in the name and the class of the company, namely RV Associates, Architects, Engineers, and Consultants Private Limited, as the same was duly intimated to the respondents by the communication dated where is the communication you intimated? Okay.
5/5/25.
Huh?
5/5/25. 5th May 25.
Page
Page 180
2025.
Page 82.
And in pursuance thereto, the respondents have also invited the petitioner on 22/5/2025 for the purpose of negotiation.
Page 83, my lord. My lord, it is also very relevant, my lord. In the said letter, my lord, calling for negotiation, they have sought for one declaration from us,
That is 22.
22/5/25.
22.
They had sought for one declaration from us, and declaration form has been given by them. In the form, they have given new name, my lord. Page 83A,
Page
83A, 83A.
83A. It is also mentioned that in pursuance to the communication dated 22/5/2025, the petitioner had duly submitted the declaration and on the basis thereof, declaration about the negotiated rate, and on the basis thereof, the letter of acceptance was issued. It was further mentioned that the declaration was submitted on 26/5/2025 by the petitioner. Where is that? Lecture 20. Wherein also it was which is annexure 20 to the affidavit in reply, wherein also it was mentioned that the said declaration was being submitted on behalf of the petitioner, which was formerly known as RB Associates Architects, Engineers and Consultants Private Limited, in consortium with MS Prabhavi. It was further mentioned that since the name of the lead member of the consortium, that is RB itu consulting itu architects has been changed to RB, lead member of the consortium, namely MS RB Associates Architects, Engineers and Consultants Private Limited, have been legally changed to MS RB Engineering Consultants Limited. It did not affect the rights and liabilities of the company. And the constituent members of the consortium remained unchanged. And additionally, the original joint bidding agreement remained fully in force. In the backdrop of the above pleadings and the documents enclosed therewith, this court have heard the learned counsels appearing on behalf of the parties. Mr. S. Sharma, the learned counsel appearing on behalf of the petitioner, submitted that in terms of section 13 of the Companies Act 2013, any change in the name of the company shall be subject to the provisions of subsection 2 and subsection 3 of section 4 and shall not have effect except with the approval of the central government in writing. The Learned Council, referring to the proviso to subsection 2 of section 13 of the Act of 2013, submitted that even the approval shall not be necessary when the only change in the name of the company is the deletion therefrom or addition thereto of the word private consequent on conversion of any one class of companies to another class in accordance with the provisions of the Act of 2013. The Learned Counsel for the petitioner further referred to section 18 and more particularly subsection 3 of section 18, which stipulates that the registration of a company under the said section shall not affect any debts, liabilities, obligations, or contracts incurred or entered into by or on behalf of the company before conversion of such debts, liabilities, obligations, and contract may be enforced in the manner as if such registration had not been done. On the basis of the said provision, the Learned Counsel, appearing on behalf of the petitioner, submitted that a perusal of annexure
Page 40, my lord.
where is the conversion?
Page 40. Page 40.
40.
40.
40?
40.
Annexure 9, page 40.
40. Perusal of annexure 9 to the writ petition would show that a conversion, that a change of the name and the conversion from private limited company to limited company was made with the due approval of the central government. And the same have been duly permitted, as would be seen from the order dated 6/2/2025, order as would be seen from the certificate dated 6/2/2025 issued by the Ministry of Corporate Affairs. The Learned Counsel therefore submitted that in view of section 18(3) of the Act of 2013, the joint bidding agreement entered into by and between RV Associates, Architects, Engineers and Consultants Private Limited with MS Prabhabi would have the same effect upon such conversion as in view of the legal fiction being created under section 18(3) of the Act of 2013. In addition to that, the Learned Counsel submitted that the very basis of issuance of the letter of acceptance upon the petitioner is based upon the negotiations which was called for by the communication dated 22/5/2025 and the declaration so submitted by the petitioner as the lead member by the communication dated 26/5/2025. The learned counsel therefore submitted. The learned counsel further submitted that even in the bank that it is not the case that the petitioner did not seek for extension. Inasmuch as the petitioner, by Annexure 3 and Annexure 4 to the writ petition, duly sought for extension. Even the bank guarantee which was submitted as a performance guarantee not only included the name of the petitioner, but also the former name of the petitioner. The learned counsel therefore submitted that the impugned order so passed on 3/9/2025 appears to be on the basis on complete non-application of mind and suffers from malice in law. Anything more? Anything more?
Right.
Mr. Kigoi, yes, what is your submission?
We already also indicated that can taken in the paragraph, otherwise by operation of law.
Mr. Kigoi, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 submitted in terms with the pleadings of the respondent numbers 1, 2, and 3. Should I say anything about 18.3 you have conceded? No, I don't. Won't say.
By operation.
Yes. And further submitted that the implication of section 18.3, that the submission so made as regards the implication of section 18.3 of the Act of 2013 by the petitioner does not appear to be correct. I've heard the learned counsels appearing on behalf of the parties and have also perused the materials on report. Before dealing with the facts, this court finds it pertinent to take note of some of the provisions of the Act of 2013. In terms of section 13 of the Companies Act 2013, of the Act of 2013, it is stipulated in subsection 2 that any change in the name of the company shall be subject to the provisions of subsection 2 and subsection 3 of section 4 and shall have no effect except with the approval of the central government in writing. In terms with subsection 3 of section 13, when any of the Act of 2013, when any change in the name of the company is made under subsection 2, the register shall enter the name new name in the register of companies in place of the old name and issue a fresh certificate of incorporation with the new name, and the change in the name shall be complete and effective only on the issue of such certificate. Now let us go take note of section 18, which is of vital relevance. The said section, therefore, is reproduced hereunder. A perusal of the above quoted provision would show that a company of any class registered under the Act of 2013 may convert itself as a company of other class under this Act of 2013 by alteration of the memorandum and articles of company in accordance with the provisions of Chapter 2 of the Companies Act. In terms with subsection 2, upon an application for conversion being permitted by the register of company, the former registration of the company shall be closed and a fresh certificate would be issued in the same manner as its first registration. In other words, the company prior to conversion would no longer be registered, continue to remain registered. And it is only the new company, it is only the company which has been converted would be registered by issuance of a certificate of incorporation. Subsection 3 of section 18 is of vital relevance inasmuch as the change, inasmuch as the fresh registration so granted by issuance of a certificate of incorporation shall not affect any debts, liabilities, obligations, or contracts incurred or entered into by or on behalf of the company before conversion. And such debts, liabilities, obligations, and contracts shall be enforced in the manner as if such registration had not been done. First, applying the said provision to the facts of the instant case, it would be seen that pursuant to the approval of the central government, the name of MSRB Associates Architects, Engineers and Consultants Private Limited were changed to RV Engineering Consultants Private Limited. And pursuant thereto, in terms with Section 18 of the Act of 2013, the class of the company having been changed, having been converted from private company, private limited company to limited company. The certificate of incorporation, fresh certificate of incorporation was issued in favor of the petitioner. In view of Section 18(3) of the Act of 2013, all debts, liabilities, obligations, or contracts incurred or entered by RV Associates, Architects, Engineers and Consultants Private Limited shall continue to remain in force as debts, liabilities, obligations, and contracts of the RV Engineering Consultants Limited, that is the petitioner. The fortiori, therefore, is that the joint bidding agreement so submitted by the petitioner, by MSRB Associates, Architects, Engineers and Consultants Private Limited in consortium with MS Prabhavi, by legal implication, by legal implication, by legal fiction, shall be construed to be the agreement, joint bidding agreement of the petitioner in consortium with Prabhavi. In fact, from the materials on record, it further appears that the respondent authorities have also recognized it earlier upon attention being drawn by the communication dated 5/5/2025. Inasmuch as on 22/5/2025, the respondent authority called the petitioner company for negotiation and asked the petitioner company to submit the declaration on the negotiated rates. The petitioner company submitted the negotiated rates on 26/5/2025, which was duly accepted and on the basis of which the letter of acceptance was issued. The actions thereafter taken by the respondent authorities to disregard and ignore the conversion of RV Associates, Architects, Engineers and Consultants Private Limited to that of RV Engineering Consultant Limited, that is the petitioner, appears to be not only contrary to their own conduct, but also contrary to section 18(3) of the Act of 2013. This court further duly takes note of that the petitioner had submitted representations requesting extension. The respondent authorities, after the period of 15 days from the date of issuance of the LOA, did not take any steps for cancellation. Rather, the petition respondent authorities continued to grant extension to accompany to the joint venture of RV Associates Architects, Engineers and Consultants Private Limited in consortium with MS Prabhavi. The petitioner thereupon submitted the bank guarantee issued by the ICICI Bank Limited, the details of which have been already mentioned in the previous segments of the present judgment. In the said bank guarantee, it was also mentioned the name of the petitioner, which was and its former name. The respondent authorities, however, it further appears from the impugned order that the respondent authorities, however, in complete disregard to the action for issuance of the letter of acceptance based upon the negotiated declarations, upon the declarations made by the petitioner, and in contrary to and having ignored the provisions of section 18(3) of the Act of 2013, have rendered the deceased impugned order contrary to the provisions of law, as well as on the facts of the instant case. Considering the above, it is therefore the opinion of this court that the impugned order dated 3/9/2025 cannot be sustained in law, as the same amounts to ignoring the statutory provisions of law, as well as ignoring the statutory provisions of law, which is section 18(3) of the Act of 2013, and accordingly, it is liable to be interfered with. Accordingly, the incident with petition therefore stands disposed of with the following observations and directions. The impugned order dated 3/9/2025, issued by the respondent number so and so, thereby terminating the letter of acceptance dated so and so, as well as forfeiting the bid security, forfeiting the what is that bid security? No? Bid security is illegal, is bad in law, and accordingly stands interfered with. The impugned order dated 3/9/2025 therefore stands set aside and quashed. Number 3, the respondents therefore shall take appropriate action as per the law. Mr. Gogoi, I think in that order, I need to also mention, I give a declaration also, that the joint bidding agreement so submitted by so and so shall be deemed to be the joint bidding agreement. The joint bidding agreement so submitted by RB so and so in consortium with Prabhavi, MS Prabhavi, shall be deemed to be the joint bidding agreement of so and so with in consortium with Prabhavi. That I put it. Because if I put it, then it becomes easier.
Need be cases, your lordship. Pertaining to this matter, your lordship, I have obtained telephonic instruction where it is clearly stated that no permission has been given for operating this, your lordship, in Kamrup Rural Metro. Only once, your lordship, Ahunga, your lordship,
It is also Kamrup Metro.
but.
It has been only
RGP
given at
Borwa-
Ahungaon, not here.
Not here, RGP Borwa Road, your lordship. That needs to be clarified, your lordship, from our part, I already.
So it will be deemed to be only a private tutorial and it shall not affect therefore the.
Anyway, my lord, we are also shifting from there, but within March we will complete our shifting in because building, everything has been completed. Just now. So my only the problem is that our science laboratory is there. It may take some time. Otherwise.
I'm not concerned with what you did.
Yes.
I'm only concerned with his case.
He is, and my lord, he is now, last since 9 years, he is enjoying interim. So that may be continued and by, lordship may grant up to time up to March, we will shift.
Why should I give you time?
My,
Your college is not the question.
yes.
But
Only
this
the
court shall
citizen.
deem that cannot be, I'll mention it.
My-
that
They may continue, yes.
No, I'll say that for all effect and purpose, it can, without a recognition being given by them, by you. It cannot be considered to be a college or an educational institution. Under such circumstances, the impugn order is interfered with. This has to end. It's a 2016
Yes.
matter. It
Yes.
doesn't look
But-
nice. What will people say? What is wrong with the High Court? They have.
My concern is that this, my lord, students' academic interest is involved, my lord. And we
What
are shifting
interest?
by March. We are shifting by March 2020.
No, I'm not concerned whether you shift or don't shift, that is here. But you will be only there. Madam, your presence is required. You are the main person,
Although, your lordship, we have not made party.
not necessary. Because you have submitted an inquiry.
Submitted by board now. Seba.
Whatever may be, they have submitted an inquiry report and in that inquiry report, it has been mentioned that there is a college function.
Yes.
But that college cannot be deemed to be a recognized college, taking into account that there is no recognition given beyond the initial period of 3 years.
3 years.
So therefore, under such circumstances, it can be at best treated to be a private or a tutorial classes. As such, these people, you cannot, that provision shall not bar them from continuing.
Well, only, but so far Ahunga is concerned, my lord.
I'm not concerned with
That
Ahungaon.
permission
We
is-
are concerned.
You're not
only
concerned
Zulu.
about Ahungaon.
Only Bora market,
Only Zulu.
Bora market.
Bora market over, isn't it in Zoo Road?
Yes, my lord.
Zoo Road.
Juro.
Juro.
So let us finish up this unnecessary checking for long.
It's not been submitted by me, it was submitted by TC Chutia, your lordship.
Whatever may be, you are the main person.
Or lordship, man, since I made a submission, my lord.
Don't make
Maybe
any
take
further-
after
Because-
eight, my lord.
I should have put it in the order that because of your objection, because of the petitioner has been suffering. He's into all these people. So why not compensation of 15 lakhs should not be paid to the petitioner? Pay some money. See the tension the petitioner had to engage the pricey counsels like Mr. R.M. Dekar.
No, man.
Then
I'm not that afraid. I'm not that of
these are
concern.
expensive counsels they had to engage because of you. Running out there, running an institution without the, anyway, let me write. I will see to it while writing the order, if it is possible not to say, but it has to be mentioned that you would not come within the ambit of a recognized institution.
Well, only this city is concerned, that Rajiv,
Yes,
is concerned.
Yeah, very well. Heard Mr. R.M. Dekar, the learned counsel appearing on behalf of the petitioner. Mr. R.R. Gogoi appears on behalf of the Excise Department. Ms. U Das, the learned additional senior government advocate, appears on behalf of the the District Commissioner, Mr. B.J. Ghosh appears on behalf of the respondent number 6 and Ms. P. Das
Secondly,
appears on behalf of the Secondary Education Department of the Government of Assam. The petitioner herein has approached this court seeking an appropriate redirection in order for quashing the communication dated 27/4/2016 issued by the Joint Secretary to the Government of Assam Excise Department, thereby directing the petitioner to shift his IMFL off-license
Off
shop
license.
to any other location on the alleged ground on the ground of violation of Rule 183 of the Assam Excise Act, Assam Excise Rules 1945. The petitioner further seeks appropriate directions that the petitioner may be permitted to continue to run the IMFL off-shop license, namely in the name and style of MS Rishi Wine Hut from the existing location at Bora Marketing Complex, RG Borua Road, Guwahati. At the outset, it is pertinent to observe that the Assam Excise Rules 1945 have been superseded by the Assam Excise Rules 2016. And a perusal of rule, which is the rule superseding? Huh?
289.
No.
Recalling.
No, has been superseded by the rules, Assam Excise Rules 2016. In the backdrop of the above, let this court now take note of the relevant facts which led to the filing of the instant writ petition. The petitioner herein was issued an IMFL off license on 23/7 to 1998. In a location situated at Bora Market Complex, RG Borua Road, Guwahati 5. Pursuant to that, the petitioner continued to run the IMFL off-license shop without any disturbance. On 25/2/2016, a complaint was made by the secretary of the respondent number 6 to the Secretary Excise Department, alleging that the petitioner's IMFL shop is within 20 meters of the respondent number 6, which is a degree college affiliated to the Guwahati University and providing higher education, higher secondary and degree courses in providing and where the degree college affiliated to Guwahati University providing higher secondary and degree courses. On the basis of the said communication, which was followed by, the said communication was followed by an objection filed on 29/2/2016 by the respondent number 6. Resultantly, a communication was issued, the impugned communication was issued on 27/4/2016, thereby directing the petitioner to shift the petitioner's IMFL off-license shop to any other location in conformity with the Assam Excise Rules 1945 within 15 days, failing which the license was to be cancelled. It is under such circumstances the present petition has been filed. First, the record reveals that pursuant to the filing of the instant writ petition, this court passed an interim order, issued notice, and further state the impugned order dated 27/4/2016. The interim order thereupon have been continued from time to time. The record reveals that respondent number 6 had filed an affidavit in opposition supporting the impugned order dated 27/4/2016 and stating inter alia that the respondent petitioner's shop, IMFL shop, cannot be allowed to be continued in view of the violation to Rule 183 of the Assam Excise Rules 1945. It is interesting to take note of that in the said affidavit in opposition filed by the respondent number 6, the respondent number 6 have enclosed the permission for the respondent number 6 to run its college, its educational institution, issued by the Assam Higher Secondary Council, Bamuni Moidam, dated 22/4/2002. A perusal of the said permission reveals that the respondent number 6 was permitted to run the said educational institution at RG Borua Road, Guwahati, with a condition that the said educational institution would be shifted to its own building, constructed in its own land within 3 years, failing which permission shall be withdrawn. At this stage, it is also very pertinent to mention that the respondent number 6 has been provided with the permission to run a college at Ahumgao, Kotokipara Road, Guwahati 781035. And this permission have been continued from time to time. However, there is nothing on record that after the lapse of 3 years, from the date the permission was granted to the petition respondent number 6, that is on 22/4/2002. Any further extension was granted by the Assam Higher Secondary Education Council for the respondent number 6 to continue its junior college at RG Borua Road, Guwahati 781005.
Only my lord, actually our, actually permission was granted.
No more
My lord,
remaining. Mr. Ghosh, remaining is for division bench.
I
No, no
That is
more.
my
Don't
lord.
disturb.
holding practical
Full
test. my
stop.
lord. They
No,
are
no, no.
2013 even, my.
No, whatever may be. Where is that?
This is there, my.
Show me that you have been granted an extension.
Extension, my lord, for holding this, my lord, our science laboratory is there.
No, 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 no. Where have you been given an extension?
My lord, it is, my lord, deems to be, my lord, otherwise they would not have given board of, well, a practical and science examination there. At, my Guwahati 5, there.
No, no, don't confuse this with the Ahumgaon. You want the Ahumgaon without permission?
Ahunga is there, my lord, that is was also granted. to-
Not, no, it is, no address is mentioned. Where's the address?
My lord,
Where's the address here?
my 5, yes, there, my lord, Guwahati 5, Lord, you may say, Ajurika College, Guwahati 5, that is this wood there, my. Not with- not here.
It is further seen that the respondents herein have also filed their affidavit in opposition. The official respondents have also filed their affidavit in opposition. Thereby supporting the impugned order dated 27/4/2016 on the ground of infraction to Rule 183 of the Assam Excise Rules 1945. The records further reveal that no, at this stage, it is very pertinent to observe. And at this stage, this court finds it pertinent to reiterate the Assam Excise Rules 1945 have been superseded by the Assam Excise Rules 2016, for short, the rules of 2016. Rule 289 of the rules of 2016 is relevant for the purpose of the present dispute. The said rule, therefore, stands under, as such, the said rule is reproduced hereunder. From a perusal of the above rule, quoted rule, it would be seen that no IMFL and beer retail off license or retail on license shall be established in a municipal corporation area within a distance of 50 meters in the municipality and town committee area, and within a distance of 100 meters and in Gaon Panchayat or equivalent body area within a distance of 150 meters from any place of public worship or educational institution or hospital. The same rule further stipulates as to what would be an educational institution. For the purpose of the said rule, an educational institution would mean a primary school, middle school, and high school recognized by the state government or the central government or any college affiliated to any university establishment by law, but does not include any private coaching or tutorial institution. Proviso to Rule 2 of section sub-rule 2 of Rule 289 is also of relevance. In as much as, in terms with the said proviso, where in any place of public worship or educational, where in terms with the said proviso, even when any place of public worship or educational institution or hospital comes into existence subsequent to the establishment of the licensed premises, the aforesaid distance provisions shall apply, subject to the provisions that the licensee shall be given a reasonable opportunity to shift or relocate his premises. In the instant case, admittedly, the petitioner's license was issued in the year 1998. And the respondent number 6, institution, respondent number 6 had opened its branch in the year 2002. Therefore, by virtue of the said proviso to sub-rule 2 of Rule 289 of the rules of 2016, the petitioner would have to shift provided the respondent number 6 branch would come within the ambit of an educational institution recognized by the state government or the central government. Or any college affiliated to any university establishment by law. At this stage, this court further finds it relevant to take note of the provisions of the Assam, where is that, non-governmental,
572, my lord. 572, it starts now.
Assam non-governmental educational institution bracket Regulation and Management Act 2006 and the Assam non-governmental educational institutions bracket Regulation and Management Rules 2007, which stipulates that permission is required for establishment of a non-governmental educational institution and registration. A further perusal of the regulations of 2007 would show that a non-governmental educational institution is also required to provide various details as to its building and its campuses. In the instant case, although the respondent number 6, who has its main office, main campus at Ahunga and has a branch at the Bora Market,
Yes.
RG Boulevard Road. As is apparent from the inquiry report so submitted before this court, on 12/8/2025. But the permission so granted to the respondent number 6 to run its branch at Bora Market, RG Boulevard Road was only for a period of 3 years, with a further stipulation that if the said branch is not shifted to the respondent number 6 own building constructed on its own land, the said permission would be withdrawn. Nothing has been brought on record to show that the respondent number 6 branch situated at that the respondent number 6 thereupon took steps for shifting to its own building constructed upon its own land within the time so permitted. And further, nothing is also being produced that the permission was extended. In this regard, this court finds it pertinent to take note of the submissions of Ms. P. Das, the learned standing counsel of the secondary department, who submitted on instructions that there was no extension of the permission granted to the respondent number 6 to continue its branch at Bora Market, RG Boulevard Road, Guwahati 5. Under such circumstances, it is therefore the opinion of this court that the bar which is being contained in sub-rule 2 of Rule 289 of the rules of 2016, insofar as educational institution is concerned, would not apply in the case of the petitioners, inasmuch as the branch of the petitioner, branch of the respondent number 6, continuing at Bora Market, RG Boulevard Road, Guwahati 5, cannot be considered to be recognized to come within the ambit of a recognized educational institution. Accordingly, it is therefore the opinion of this court that the impugned order dated 27/4/2016 requires interference. The instant writ petition therefore stands disposed of with the following observations and directions. The impugned order dated 27/4/2016 is set aside and quashed. Number 2, this court is not inclined to pass an order thereby permitting the petitioner to run the, not inclined to issue a mandamus directing the respondents to forthwith allow the petitioner to continue his IMFL shop. We set aside that.
Yes, madam.
That is-
You can notice.
set aside. There shall be no order as.
Deeply obliged.
I have tried not to say so much.
I understood. Obliged.
Without having a permission, why you are objecting? Management of Race Net Solutions, State of Assam. What is this?
May I please, your Lordship.
Ah,
Lordship, on the last occasion, we seek for time to pass a substitution application for respondent number 11 as he has been expired.
who expired?
Respondent number 11. In the meantime, sir has told that respondent number 3 also expired. So that we need a time to file substitution application for both along together.
Last time was granted on 6/8.
Yes, Lordship,
You
for
have not filed.
respondent.
The council appearing on behalf, there's a stay? Is there a stay? No stay.
No stay is there.
Okay, no stay is there. It is seen that it is being submitted by the learned counsel appearing on behalf of the petitioner that some of the respondents have expired and as such would like to take steps for filing amendment, increment, substitution application. List the matter after filing such substitution.
11. Obliged, Lordship.
Yes, what is this?
May please, your lordship.
So in this complaint matter, I was directed to obtain the chronological list. I have obtained the chronological list and submitted the list for the honorable court of last division. And honorable court, the petitioner has submitted that there are some persons who are below the petitioner and they got the amount. So he was supposed to file the details of both.
Tell me.
That list, possibly he has not filed. He has not filed the list.
Where is the chronological list?
That is there, that is in the court file, lordship.
What is the status of the petitioner? What is the name of the petitioner?
Petitioner is
Marigold.
Marigold Compute.
Marigold
Where is
Compute.
it?
6 and 7.
Serial number?
6 and 7.
Huh?
6, 7.
Amount liability is when? Then?
Serial number, statement of outstanding liability is second page. Serial number 6.
Serial number 6 and 7.
7.
So you have not paid anybody.
From this list, they said, kindly see the first page. They said, these are
So
the-
are you saying that for panchayat elections, nobody has been paid?
some are paid, but this is the list of income.
No, why are these tick marks? Are you saying that none of these people have been paid?
No, madam. According to my instruction, no. They say, madam, the chronological list showing the name of the petitioners along with the outstanding dues payable to him as on the next day fixed also he has given this.
Huh?
According to it is pertinent to note that the firms, contractors, suppliers mentioned in the list have not yet been paid. Payment will be made as and when funds are sanctioned by the government. So this is the list according to my instruction.
Statements showing the outstanding liabilities of panchayat election.
Yes,
Who is to pay the payment?
the panchayat department, we have already asked for the amount from the panchayat department. Department will release the amount and the deputy commissioner.
Who are you?
I'm for the deputy commissioner. Naga. He's not a party. The panchayat department is not a party here. The petition has been filed by the petitioner, including the deputy commissioner and Naga as a part, as a respondent. In fact, PMRD is not a party in the petition.
No, it was earlier.
Where's the work order? Problem arises because of you. Why have you taken the judgment with Tamsir Ali?
My lord,
Tamsir Ali had no application out here. You should have got a straightforward order that pay me within so and so.
lordship,
Then
lordship, so far I have a copy that below me, they have already paid.
show me.
Yes. Their name is as per their list below me, lordship. Only first one, except first one, other all. And whatever the amount, it is given, lordship.
This must be some other amount.
Yes, they have paid.
Pansharantra is 41,730 and so and so and so and so. There are many amounts.
Yes, their amount is more than me, lordship. And they have been given.
No, if you see the list, Pancharatna printers is at serial number 2, 4, 5 and 9.
Yes, Pancharatna is one of my below. And Surjo printer is also my below, lordship.
They have got how much?
They have got, lordship, 2,28,755.
And where is the other amount?
And next one is, lordship, that is GB.
Yeah.
GB printers. He's also below me. Gigabytes, he got 8,83,749, lordship.
2,75,000.
That's in terms
2,58,000. How much he got?
gigabytes.
Gigabytes, press and publication, does he have any other deals? Because this is not going as per that, na?
Gigabytes name is their lordship in their list.
Understood, but how do you say that it is against this amount? That might be some other thing.
No, only this purpose only, lordship.
No,
Printers.
because here his bill is
Panchayat.
2,75,000, but he has got 8 lakhs. How do you this? Pancharatna
Yeah,
is in 2, 4, 5 and 9.
yeah.
Is the total amount there? Pancharatna is so much, that is 1,93,000.
Yeah. And
Or
Surjo
is it before that?
and Surjo
This is
printer
not
also.
known. When did they pay the amount?
But they have not paid the whole amount. They are given the part amounts to them also, lordship.
But this is in connection with Panchayat election 2025.
Right.
But we are concerned with Panchayat election 12 and 30.
Lordship, because they are given 25 releasing the amount, but the
Now
13th they are not releasing.
How do you follow the chronological?
Yes.
Means if Panchayat election happens in 2025, you are going to pay them first.
Yes.
You know, the amount they have already. They have
No,
already
don't
asked
you
for.
clear the earlier amounts first?
It depends on,
Or do you only clear for this amount?
it depends on how the funds are being paid by the.
No, funds cannot be like that. You cannot delay this when there is a direction. These are 12, 13. There's a verification, this amount is payable. How can you say that, okay, now we are going to pay 2025, 26?
No,
But we will pay something whenever we get the funds. Why will the government pay for 12, 13?
No, they are in fact not the election commission and the Panchayat department. They are As per our, we are sending the requisition regularly.
Are you making the election commission a
Yes,
party?
yes, yes.
Commission,
Who is there here?
In the writ petition, Lordship. it
No,
was.
no, here.
No,
In the writ petition, it.
No, here.
We are not Lordship. In the contempt, it is not there.
Why you have not done that? Getting hold of the election commission is also good.
Actually, Lordship, what happened in the case, we have tendered before the deputy commissioner, not Panchayat.
Understood. Have you not made the Assam election commission a party?
In the petition, we have made.
Then where is the order? Order categorically also says petition is disposed of, Iman, the aforesaid so and so, Iman, so and so, on when the funds are available on pro rata basis. And you shouldn't have first got the question of Tamser Ali. Getting Tamser Ali is a big problem. Now, you should have made them a party.
Actually, I made the party Lordship in my writ petition, and it is the writ petition direction, Lordship.
So, why didn't you ask the state election commission? You have to give me the handle also.
Lordship,
You should have made the PNRD also a party,
Lordship.
a finance also a party. This is how you get it done. Huh? You can't make it only the deputy commissioner.
and the deputy commissioner who is a party here, he is already, the new incumbent has come. The person who is respondent here, he is no longer holding the post of DP, deputy commissioner. One of the new incumbent has come, so he has to be included here. Ultimately, from the ADC concern, I have taken the instruction. My information is that they have requisition, they have sought for the amount from the department, but the fund is not yet, they have not received the fund yet.
No, you see the thing is, have you taken up the action for getting the funds?
Yes, ma'am.
When did you write last?
I have taken it. But this is the last meeting. In 2022 also we have given, and these are the.
And they are not giving importance.
Fund they have not. Fund they have not. Some communication of 2022, 24, and the latest of 25. But the pending liability is 74 lakhs of the pending election 12. The pending liability is 74 lakhs, 90,523.
Mr. Deennath, the learned senior government advocate, has submitted that a chronological list have been prepared wherein the petitioner is at serial number 6 and 7, 5 and 6, 6 and 7. And whenever the funds are available, the payment will be made. The learned counsel appearing on behalf of the respondent further submitted that various demands have been made to the Commissioner and Secretary to the PNRD Department for release of the funds. However, the funds have not been released. In addition to that, it has been also submitted that the respondent herein is no longer holding the post of the district administration, district commissioner. Which one? Nagaon.
No,
This court inquired with Mr. So-and-so, the learned counsel appearing on behalf of the petitioner as to why the secretary, why the Assam State Election Commission have not been intimated about the order so passed by this court. And further, why the present incumbent have not been implemented. The learned counsel submits that you do the needful. This is the matter of the 6 weeks. In the meantime, what you do, you submit this. Submit to representative, enclose that order, my order, the order passed by that, and give it to both the DC and the secretary and the whoever the Assam State Election Commission, whoever the person. And thereupon file impeachment application before this. Okay, then I can take some.
When one date maybe then one date can be fixed also.
I'm giving you 6 weeks.
Lordship,
How do I give you a date unless you file that application?
it will be Commissioner PNRD. Commissioner PNRD. The,
PNRD, I can't make him a party now.
the lordship has directed, dictated, Commissioner and Secretary. Lordship has dictated as Commissioner and Secretary PNRD. Like it is to Commissioner PNRD.
To the
PNRD
commissioner,
is the Commissioner.
Commissioner PNRD.
Commissioner.
The instructions so placed by Mr. D. Nath appearing on behalf of the respondent is kept on record collectively and marked with the letter X. Hey, good evening, huh? Mark the X. Okay. Well, otherwise you won't get. First of all, you should not have taken this Tamser Ali business. You want one order, Tamser Ali and come over. And Tamser Ali creates huge because you see, except BTC and PWD, nobody follows Tamser Ali. And it becomes a difficult.
Lordship.
Yes, review. What is this?
May I please, your Lordship? Lordship, we have filed 11 mutation appeals, Lordship.
Huh?
We have filed 11 mutation appeals before the District Commissioner, Borpeta, in the year 2021. Those mutation appeals were not considered, therefore, Lordship, we have filed a writ petition wherein your Lordship directed us to file fresh appeals because they lost their relevant records. Lordship, during the pendency of the writ petition, Lordship, those mutation appeals which were subject matter of challenge in those entire records was changed, Lordship.
What?
Lordship, the entire mutation records was changed during the pendency of the writ petition. And therefore, Lordship, as of now, those mutation orders which were subject matter of the appeals which were filed in 2021, those does not exist. Now there is a difficulty for us to file appeals.
Why?
Challenging the fresh mutation in view of the order passed by your Lordship.
What did you do initially? Why did you come before this court?
Because Lordship, in the year on
We
4/5
go by the learned
2021,
counsel appearing on behalf of the petitioner.
at page
So
22,
on behalf of the instrument has been filed being agreed by part of AI not deciding 10 appeal
Lordship.
which were filed by the petitioner on so and so challenging the mutation order in respect of land measuring so and so.
Lordship.
This court by the order issued no and directed the respondent to apprise this court as to whether the appeals have been duly received by the office. On so and so H. Sharma appearing submitted to the page on the file number which have been provided by the surveyor could not be located. He, however, in view of the additional affidavit filed by Divan and here being so and so submitted the so and so upon inquiry it came to light that there was a petitioner's notice issued by the advocate on behalf of the petitioner on account of inaction on the part. In the state pleader's notice, there were reference to 10 appeals, of which the first page of the appeals were also enclosed. The learned counsel appearing on behalf of the petitioner submitted in view of the first page of the EP3 that 10 appeals were filed by the petitioner and were received by the office of the declaration on demand. However, they did not have the records of the same. In addition to that, the learned counsel appearing on behalf of the district administrator submitted that on an impolite influence the case has been initiated by the circle officer on the basis of the pleader's notice and notices have been given. Then what happened?
Lordship, in view of the order passed by your Lordship, we went to the Borpeta for filing the appeal, fresh memo of appeals before the district commissioner. District commissioner did not accept it, citing some developments.
Huh?
He did not accept the appeal, citing some changes, Lordship. And then when we inquired on 13/12, your Lordship will find it page 30.
No, come to the point.
Lordship,
What happened thereafter? After my order, I have asked you to file within 15 days the memo
Lordship,
of appeal.
we went
Did
there.
you file or not?
Lordship, those appeals were not accepted. Seeing
Okay,
that
was not accepted. Then
after that, Lordship, we tried to find out what actually had happened. And then on 13/12/2024, Lordship, we applied for a certified copy of the mutation and Jamabandi. And then we find out, Lordship, at page 35, your Lordship will find the mutation entries which were subject matter of the appeal, those were cancelled, Lordship, by the district commissioner and the circle officer.
you were concerned. Why did you file the appeals initially?
Because, Lordship, those appeals were against us. Sorry, those mutation entries were,
Were made against you.
yes,
Now against that you filed appeals.
Lordship,
Now the appeals were not decided for which you came before this court.
exactly.
I directed you to file the appeal fresh copies, taking into account that the date of filing the appeal will be on that date
Yes,
and for the purpose of reconstruction.
yes,
After that, you went out there, they did not accept.
yes,
When it was not accepted, now what has happened means earlier orders which you have challenged
those
is
were
no
cancelled.
longer there.
Yes.
So if it is no longer there, why are you aggrieved?
Because some of the orders they cancelled and some of them they did not cancel. And therefore, we cannot file 11 appeals in view of the order passed by your Lordship.
No, you don't need to file 11 appeals. If they have cancelled, very well, you should be happy with it.
Lordship,
You shouldn't say no.
No, we
I'm
are
not going to
happy-
Press that appeal.
we are absolutely happy with that, Lordship. But the
Then-
fact is that since your Lordship directed us to file 10 appeals,
No, if you file an appeal
Lordship,
and if the appeal have not been taken on board
Lordship,
in spite of that order, isn't it a case of contempt?
Lordship,
Where is the consent of review? What mistake I did?
no, this is a change in circumstances. Therefore,
Change in the circumstances would be a separate cause of action. Don't you think so?
but
It may be at best the case wherein a person, you may say, the court's order have been disregarded. One, that
Lordship,
he has not accepted it. Or we don't need to file so many appeals now in view of the change in the circumstances that So we are not pressing on that. Some orders have been already cancelled.
Lordship,
So how on earth is it a case of a review?
because Lordship, during the pendency of the repetition, they changed the entire scenario.
So what? You should be happy.
We are happy with that, Lordship,
Then why are you filing a review?
because your Lordship has specifically directed us
So
to
you
file.
went there.
Lordship,
They did not accept.
Lordship,
So if they don't accept, It's a case of contempt.
Lordship.
It cannot be a case of review. Where's the error? You need, what are the parameters for review? An error appeared,
Lordship.
or some due diligence, some things which were there you could not find out.
Lordship.
Both the parameters or sufficient reason. The sufficient reason has to be analogous to 1 and 2. It is not. So how is the question of review? Dismiss. Withdraw.
Lordship.
Mr. So-and-so, appearing on behalf of the petitioner, submits. The petitioner herein would not like press the instant review application without prejudice to the rights of the petitioner to start further course of action if so necessary.
Lordship.
Taking into account the above, the instant review petition stands closed on withdrawal. So the withdrawal of the instant review petition shall not foreclose the right of the petitioner to take such other action as as advised in terms with the order dated 12/9/2024, passed in WPC number 4109 of the 2000.
Lordship. Lordship. Obliged.
Mr. Joy Hendig appears for the. What is this? I for what?
For implement, my lord. Implement.
Impeding whom?
My lord, Ministry of Jal Shakti, my lord.
Why?
Because my lord, the petitioner is the contractor under the water resources department.
Is an application filed by the applicant who is the petitioner in the petition number 5520 of the 2024. Seeking implement of the opposite party number
6, 7, 8, and 8.
6, 7, and 8 to the accompanying writ petition on the ground that the scheme under which the petitioner seeks recovery of amount from the respondents is a scheme of the respondent number 6 and 7. So taking into account the above, it is the opinion of this court that opposite party number 6, 7, and 8 is required to be brought on record, ought to be arrayed as parties, as respondents in the accompanying petition. Accordingly, the opposite party number 6, 7, and 8 are arrayed as respondent number 6, 7, and 8 to the accompanying writ petition. The counsel for the petitioner is directed to file fresh memo of parties before the registry of this court within 7 days, and the registry shall on the basis thereof make necessary correction on the records and
They may be allowed to check.
update the
check.
same in the CIS. Number 2, petition. You are appearing? Ms. A. Gayan appears on behalf of the respondent numbers 1 and 3, newly impleaded respondent number, issue notice upon the newly impleaded respondent numbers 6, 7, and 8. Full stop. Ms. A. Gayan accepts notice on behalf of the respondent number 6 and 7, and so appears on accepts notice on behalf of the respondent number 8. So extra copies of the writ petition be served upon them within 3 days. Full stop. The respondents number 6, 7, and 8 shall bring on record their stand by filing the affidavits on or before 8th of December 2025.
Oblige. 14.
For 1 week time. Can they stand for one?
But tell me, notice has to be issued about 7, 8, and 9. Who are 7, 8, and 9? Huh?
7, 8.
Who is respondent number 7, 8, and 9?
7, 8, 9.
You are accepting notice.
Yes, madam, except 9, madam, finance department.
Finance is, anybody from finance, did you see today? A. Solia,
Bogo.
Gogoi, did you see him in the court today?
Yes, madam. I have seen in the morning. It was long time sitting idly, so I forgot.
Okay. Issue notice.
I have already served notice to the respondents, Lordship. Without having
Mr.
also,
Counsel, see, when Respondent number 7 and 8 and 9 have been included.
Yes,
Isn't it the law that you have to issue notice?
yes, sir. And
But you
actually,
want that without issuing notice?
No, no.
I should pass on.
actually without court
Why
order,
will
I,
they file affidavit?
yes.
You want these 3 persons, why will they file affidavit? Tell me. Or bring the instructions without notice being issued? Issue notice upon the newly impleted respondent number 7, 8 and 9 returnable on to 10th of December 2025. Ms. So-and-so accepts notice on behalf of the newly impleted respondent number 7 and 8. Mr. B. Gogoi accepts notice on behalf of the respondent number 9. Extra copies of the writ petition be furnished upon them by Monday. Full stop. The respondents are directed to bring on record their stand by filing the affidavit on or before 8th of December 2025. Finished.
I have already served them. That is what I was saying.
Mr. Counsel, don't you file, before filing the requisition, don't you serve a copy of?
No, not that, Lordship. After implement order, although there was no order to serve notice, take steps. But I took the steps, I served the copy to them.
So what should I do?
No, Lordship. Let the order remain, Lordship.
You have to serve.
Yes.
एक वन ही कुछ भाई दिखती एक मैं तो contempt के साथ और एक भी टाइम डिलीवरी दी ना